We don't have a quorum present yet, but hopefully we will have one soon. We are holding this hearing pursuant to, at least on the House Rule 10.01, which allows us to hold hearings in a digital platform in order to observe the social distancing public health regulations related to COVID. Today, members, we're going to be going over two provisions that the House is dividing up into two separate offers, and we do that for the purpose of grouping the bills together. The first one will have provisions under the broad title of supporting crime victims and survivors of crimes. And the second offer will focus on additional judiciary provisions. We'll have members of the House Conference Committee introduce the offers and then have nonpartisan staff walk through the provisions, and then we'll wrap up with taking testimony on some of the provisions, not all, in the offers, and then have discussion. We'll take up each one of those separately. So first part of the committee hearing then will be focused on supporting crime victims, and then the second part will be on judiciary provisions. And Senator Limmer, just very quickly, just checking in to see if the Senate has made any progress with any of the offers that the House has put forward at this time.
Mr. Chair, we've been looking over your offers, trying to understand them better. Most of them are fairly clear in understanding. However, I'd like to reemphasize I'm seeking a more holistic global offer included in with just everything. I was wondering, I see that you've provided two more pages of offers, 25 separate pieces of legislation. And I was just wondering, is this the end of your offers? Or will you have more as we progress?
Chair Limmer, frankly, my hope is that, my real hope is that the Senate will respond to at least one of these offers, and hopefully we'll put one together that will really tempt you, and then we can move forward. But we'll continue to make offers, as long as we're meeting. Our goal is to, you and I share the same goal. We want to build a bill together that we can agree on and get that done by the time that we've been allotted to do so. So I would still anxiously anticipate any responses that the Senate has or anything before us, and let us know when that might be coming, and we'll just keep pushing forward.
Mr. Chairman, you and I both have we're in the same predicament. We're waiting for our leaders to give us a budget target that we can really begin to put a bill together on. Although this bill is kind of divided in two parts. We have the budget part, and then your side has a number of proposals that are not necessarily connected to a budget. And so we are still in a holding pattern with that budget target. But nevertheless, as I said earlier, we're looking over your individual budget or non-budget policies and trying to understand them as well as we can. And I'm hoping that in time we'll finally get to a point that the collection of proposals will actually reflect a more global presentation.
Chair Limmer, we might just get there by default.
We might.
For sure. And I have heard a Senate position till now. I would submit, the House's position is that we don't, frankly, need to wait for budget targets in order for us to make progress on policy provisions. I would also say that a number of those policy provisions include provisions that some majority members have introduced, have worked on. Some, quite frankly, have worked on for many, many months. And a number of those provisions, even on the House side, have enjoy good bipartisan support. So there's certainly the stuff on the table for us to be able to not have to wait until budgets targets in order to do the very important policy work. Members, you all heard some of the testimony in the last week, some of it, quite frankly, quite heartrending, that don't require us to make, to be limited by budget, decisions in order for us to respond and to not only create justice and peace and comfort for Minnesotans, but to put forward some really good policy to avoid, further harm. And so it's in that spirit that I hope that the Senate will be able to respond. And obviously, when we get those targets, we'll be also dealing with those issues as well. All right, members, with that, we're going to move on to the
Mr. Chairman.
Yes, Senator Latz.
Thank you. On that point, before you
Please.
move into the rest of the agenda,
Yes.
if I may take the liberty, I'm not one who usually brings religion into my public policy conversations. I just generally think it's best for the protection of both to keep them separate. But I know that it has become a point of consideration and a reference point for some of our testifiers and for some members of our conference committee. So I thought I would turn to a tradition, which is not mine, but which is a tradition, the faith tradition of the majority, and highlight a couple of messages which I have identified from that tradition. And perhaps we can consider it as we decide how to move forward here. James 4:17 reads, "So whoever knows the right thing to do and fails to do it, for him it is sin." Proverbs 3:27 reads, "Do not withhold good from those to whom it is due when it is in your power to act." And Matthew 25, verses 44 to 45 reads, "They also will answer, 'Lord, when did we see you hungry or thirsty or a stranger or needing clothes or sick or in prison and did not help you?' He will reply, 'Truly I tell you, whatever you did not do for one of the least of these, you did not do for me.'" So I ask that we consider those words of wisdom as we consider what actions to take in these times and with these policy proposals when we have the capability, the power, the capacity, the knowledge to take steps to do the right thing. For, as James has said, failure to do it is, in the view of the Christian faith tradition, failure to do it is a sin. Thank you, Mr. Chairman.
Thank you, Senator Latz. Yeah, I actually thought of James as well. A little later in James, he writes, "Show me your faith apart from your work, and I will show you my faith by my works." So there's an action call that runs through our common civilization for sure. One of the things I actually do enjoy about our floor sessions is that we always open up with words of prayer and wisdom from different faith traditions. And, there are folks who would argue that it has no place in our civic government. I just can't think of our existence without those guidance, not so much to tell us what to do, but to tell us to have the humility to be with one another and to act. So I appreciate your focusing on this. Chair Limmer.
Mr. Chairman, I was going to say something, but I think I'm going to pause and not say it.
Very well. Thank you, Chair Limmer. All right, members, let's see, where was I? Oh, back to the agenda here then. So the first part of the agenda will focus on supporting crime victims and crime victim survivors. And I've asked Representative Mueller, who's the vice chair of the Judiciary Committee, to walk through the proposals in that first offer under that heading. And so I'm going to ask our Representative Mueller to come forward and to do that. And then we'll have, as I said earlier, nonpartisan staff walk through the language that Representative Mueller is pointing to. Representative Mueller.
Thank you, Mr. Chair and members. So as was mentioned, the House today has an offer related to language that's in the House Omnibus bill that supports victims of crime. And the offer lists 13 bills. And I will say that several of those bills are already in the Senate Omnibus bill. All of the bills in the House offer have bipartisan support, either with GOP co-authors or authors or GOP votes in committee. And we do have some testifiers today in support of these bills, but just so members know that we don't plan on taking testimony on every single one of these. We'll focus on some of the provisions that have not been heard in the Senate, or where there were some areas where there have not been much discussion in the Senate. And, really we decided to have nonpartisan staff take us through a walkthrough of this bill because we heard what our colleagues in the Senate were saying about wanting to talk more about the actual language of the bill. And so with that, Mr. Chair, if we can go ahead and have nonpartisan staff walk through the different provisions that are in the offer, I think that would be helpful.
Very well. Thank you, Representative Mueller. I believe we'll start with Ben Johnson from House Research. I believe. If not, Mr. Diebel.
Yeah, Mr. Chair, this is Jeff Diebel.
I guessed wrong.
No problem, Mr. Chair.
Jeff Diebel from House Research.
Yeah. Thank you, Mr. Chair and members. The first item on the House offer is the Criminal Sexual Conduct Working Group recommendations, and that contains almost identical language. The only exception is there's a provision in the House language that would add the new offense of sexual extortion to the crime of violence definition in Chapter 624, and that is specifically related to disqualification for firearms, but it also applies through cross-reference in various other places in our code. Moving on to number 2 on the list, the BCA investigation of sexual assault allegations among National Guard members. This would be adding an additional task to the recently created use of force investigation unit housed in the BCA. And this would require that agency to investigate cases where one Minnesota National Guard member assaults another Minnesota National Guard member within the state. And there's a related provision to this in Section 27 of the House language, which directs law enforcement agencies that receive a report of these type of cases to direct them to the Bureau of Criminal Apprehension's Independent Use of Force Investigation Unit for investigation. Moving on to number 3 on the House offer, this is the immunity for sexual assault victims and those who assist sexual assault victims. This is modeled after the drug overdose immunity statute that the state has adopted in recent years, and would extend immunity from drug possession and underage consumption charges if the evidence is obtained from a person who sought medical assistance or just emergency response assistance for a victim of sexual assault. And also the victim of sexual assault would not be charged with an offense if the evidence of the violation of drug possession or drug paraphernalia possession and or underage consumption, if the person was under the age of 21, was obtained because they sought the assistance of law enforcement or, well, specifically law enforcement, but just to call the 911. Moving on to section 4, or provision 4 of the House offer. This is the sexual assault statute limitations elimination provision, and it eliminates the existing statutes of limitations that apply to sex trafficking and 1st through 4th degree criminal sexual conduct offenses, and provides that the charges for these offenses may be brought at any time after the commission of the offense. Mr. Chair, I'm going to pass the presentation off to, I believe, Mr. Johnson to cover items 5 and 6.
Well, thank you, Mr. Diebel. Mr. Johnson.
Mr. Chair and members, I'm going to be talking about items 5 and 6 on the offer list. The first item relates to the survivor support and prevention grants. The provisions appear in Article 1, which is, it's actually Article 2 of the bill, but Article 1 side by side on page R15. Page 15, well, excuse me, line 15.29. There's an appropriation there of $6 million. And then the policy is in Article 15 side by side, page R38. It's section 35 of the House bill in that article, line 319.2. Subdivision 1 establishes grants to address the needs of victims. It establishes 2 types of grants. First, the grants would be to provide direct financial assistance to victims. And second, the grants would be to organizations to meet emerging and unmet needs of victims. Subdivision 2 establishes the eligibility requirements for those 2 types of grants. It directs the director of the Office of Justice Programs to work with advocate groups to establish procedures and priorities for direct funding. And it also requires prioritization of certain victims. It also requires prioritizing the expansion of services to underserved populations. In relation to the amount of the appropriation, it directs that at least 30% of the amount be directed to each of the 2 types of grants, so a minimum of 30% to each of the grants. The third subdivision requires a report every 2 years to provide information about the grants issued, including the number of grants issued and the amount of those grants. The next provision I'm going to talk about it contains modifications to the Safe at Home program. This language appears in both Articles 5 and Article 8. In Article 5, the side-by-side, pages R1 and R2, sections 1, 2, and 3. Section 1 clarifies the definition of mail in that program to establish that the definition does not include packages and parcels unless they're clearly identifiable as non-refrigerated pharmaceuticals or indicate that they were sent by a government entity. Section 2 clarifies that a participant in the program may present an address designated by the Secretary of State to a person or entity. And Section 3 clarifies that a landlord may not display the name of a participant in the Safe at Home program at the address where the participant resides. In Section 8, the provisions appear on pages R2 through R6. Those are sections 2 to 5 of the House language, beginning on line 77.28. Section 7 amends the definitions of location data to specifically refer to data that the participant identifies, and also amends the definition of real property records to refer to data assessments, real or personal property taxation, and other data on real property. Section 3 amends the provisions regarding how a program participant shall notify a government entity of the participant's protected status in the program. Section 4 makes technical changes regarding the classification of data and data sharing provisions. And Section 5 makes conforming changes to reflect the expanded definition of real property records. It also permits sharing of a participant's identity to another government identity in conjunction with real property records for purposes of administering the assessment and taxation laws. Finally, it requires the Secretary of State's office to be notified when there's a change regarding the protected status of a participant's property records. Mr. Chair, I'd ask that you turn it back over to Mr. Diebel to proceed.
Thank you, Mr. Johnson. Mr. Diebel.
Mr. Chair and members, picking up with item 7 on the House offer, it's titled and timely processing the U visa certification documents. This is section 8 of the House article 5. And this is a language that's been, I believe, considered the last 2, perhaps 3 sessions in the legislature. And it directs law enforcement agencies to process U visa applications. And U visa applications are those that are from persons who are here and undocumented, but are needed to help and with a prosecution or investigation of a crime. And so there's a special provision that allows those folks to stay so that we can, that law enforcement can rely on their knowledge of the case to help them see cases through to either investigation or conviction. The requirement is that the agency must process a request within 90 days unless the person is facing removal proceedings, and then they must process the request within 14 days. And it also requires that each agency would have a designated person responsible for processing these requests so that they don't get lost in the paperwork at the agency, that they have one point of contact to process these requests. Moving on to Section 8 of the House offer. This is a model policy that the Post Board is tasked to create related to human trafficking cases, and it would require them to do both sex and labor trafficking provisions, and would provide guidance for agencies to investigate these type of cases. Also, the statute requires each agency in the state to adopt a model policy that's identical or substantially similar to the model policy proposed by the agency. And the provision also requires that the agencies enforce the application of the policy and make sure that their officers are trained in the implementation and procedures set forth in the investigation process. Mr. Chair, that brings us to item 9, and Mr. Johnson will pick up from there.
Thank you, Mr. Devo. Mr. Johnson.
Mr. Chair, item 9 on the list relates to trafficking provisions. The vast majority of these items are in both the House and the Senate bills with nearly identical language. All of the House provisions appear in Article 14 side by side. The first one I'll talk about appears on page R15. It's section 14 of the House article. It adds a violation of section 609.322, which is sex trafficking in the first degree, to the definition of violent crime. On page R17, section 17 of the House language removes a reference to a misdemeanor violation, which is repealed in the article. On page R21, section 21 increases the maximum sentence of imprisonment for a person who commits sex trafficking in the first degree from 20 years to 25 years, and also increases the maximum sentence of imprisonment for a person who commits sex trafficking in the first degree when any of 4 aggravating factors are present from 25 to 30 years. The next provision is on page R22. It's section 22, and that increases the maximum sentence of imprisonment for a person who commits sex trafficking in the second degree from 15 years to 20 years. Section 23 is also on page R22, and it amends the age at which engaging in prostitution with a minor victim results in a penalty of up to 20 years. That age changes from 12 to 13 years old. Section 24, which is on page R23, provides that any person who engages in prostitution with someone who is at least 18 years of age is guilty of a gross misdemeanor, and also establishes that repeated offenses are a felony. Section 25 on page R24 makes a conforming change. Section 26, also on page R24, makes another conforming change. Section 29 on page R26 increases the maximum sentence of imprisonment for solicitation of children to engage in sexual conduct or electronic solicitation of children from 3 years to 5 years, and also increases the maximum fine from $5,000 to $10,000. Section 33, which is on page R29, establishes a gross misdemeanor offense for trespassing on the grounds of a facility that provides emergency shelter services for sex trafficking victims, or a facility that provides transitional housing to sex trafficking victims and their children. Section 48, which is on page R46, directs the Minnesota Sentencing Guidelines Commission to review and consider modifying the sex offender grid based on the changes that I just walked through. Mr. Chair, that brings us to item number 10. Item number 10 involves establishing a statewide anti-trafficking investigation coordinator. The first provision related to this policy is in Article 1 of the side-by-side, which again is actually in Article 2. It's on page R15 of that document. It appropriates $1 million each year for an anti-trafficking coordinator and to implement new or expand existing strategies to combat sex trafficking. Moving to Article 15 of the side-by-side. This is Article 15 again on page R15, Section 20 of the House language, creates a new position. It's the statewide anti-trafficking investigation coordinator. The position is within the Department of Public Safety's Office of Justice Programs, and the coordinator must be a current or former law enforcement officer or prosecutor with experience investigating or prosecuting trafficking-related offenses. It establishes the duties and responsibilities of this position, which includes coordinating multi-jurisdictional sex trafficking task forces, providing technical assistance, promoting the efficient use of resources, and helping with the appropriate distribution of grants. Mr. Chair, also on pages R34 and R37, sections 30 and 31, remove some language authorizing training as a component of certain grants related to preventing and investigating sex trafficking. The training grants wouldn't fall under this new coordinator's authority. Mr. Chair, moving to item 11 on the list, this is the Office of Missing and Murdered Indigenous Relatives. First provision is in Article 1 of the side-by-side on page R21. It appropriates $500,000 each year to establish and maintain the Office of Missing and Murdered Indigenous Relatives. And then we move to Article 15 of the side-by-side. Again, Article 15 on page R25. This is Section 35. It establishes an office dedicated to preventing and ending the targeting of Indigenous women, children, and two-spirited people. This office is within the Office of Justice Programs. Commissioner of Public Safety is directed to appoint a director of this office and appoint staff as needed. The office is given 12 specific duties that include advocating with agencies to accomplish the goals identified in the Missing and Murdered Indigenous Women Task Force, conducting case reviews for some cold cases and prosecutions, and recommending legislation. It directs the office to coordinate with government agencies, nonprofit organizations, and tribal governments. The office is directed to issue an annual report. The office is also given access to certain corrections and detention data and medical data when access is necessary for the office to perform its duties. Mr. Chair, moving to item 12 on the list, this is the Task Force on Missing and Murdered African American Women. First provision, again, is in Article 1 side-by-side on page R18. It's an appropriation. It appropriates $202,000 the first year and $50,000 the second year to implement the task force. The task force language appears in Article 15 on page R39. This is Section 36. The first subdivision creates the Task Force on Missing and Murdered African American Women. It's modeled closely after the Task Force on Missing and Murdered Indigenous Women. It directs the task force to collect and analyze data, identify appropriate methods to track additional data, and review existing policies and their impact on African American women and families. Language directs the appointment of members and requires that the first meeting take place by October 1st of 2021 and requires a report by December 15th of 2022. Mr. Chair, the final items on the list are DPS policy proposals. These appear in Articles 17 and 18. Article 17 is, the title is the Crime Victim Reimbursements. Majority of the changes are technical, and they address a change in terms from reparations to reimbursement. On page R3 of that side-by-side, there's a clarification that no reimbursement shall be given to a person who failed to cooperate with law enforcement, provided that determination is based on a review of information from law enforcement, prosecutors, and other professionals familiar with the case. Another substantive change appears also on page R3 on lines 334.18 to 334.19. That clarifies that reductions based on contributory misconduct cannot be based on current or past affiliation with any particular group. And then on page R7, lines 338.5 to 338.6, there's an update referencing, it currently references a phone number, and the update would also include a website. Article 18 is the crime victim notification. Section 1 clarifies the definition of convicted and conviction to include situations in which a person is subject to commitment and a finding is made that an act was part of the person's course of harmful sexual conduct. Section 2 clarifies that a victim can include a victim identified in a petition of commitment. Section 3 expands the way in which victims can request notification of the release of an offender who is subject to commitment proceedings. Section 4 clarifies that the notice of discharge provided to victims applies only to those who request notice in writing. Section 5 requires prosecutors to inform victims of their right to be notified about the release or discharge of certain offenders. Section 6 makes conforming changes related to the requirements to give certain notice to victims. And Section 7 repeals Section 253D.14 subdivision 4, which relates to victim notification of petition and release, and also repeals Section 611A.0385, which relates to sentencing and the implementation of right to notice of offender release and expungement. Again, those are provisions that are amended within Article 18. Mr. Chair, that concludes the detailed walkthrough of the House offer.
Very well. Thank you, Mr. Johnson, and thank you, Mr. Diebel. So members, we will have questions, but first what we're going to do is we're going to take testimony, not on all of these, but just on certain pieces of these 13 before you. And then we'll open up for questions and comments from the conferees. As I call your name forward, please state your name for the record. We always have to have that recorded on the record, and then provide us with your testimony. So first, to speak on the criminal sexual conduct reform, we have Kylo Marie Granda, who is a steering committee member representing victims, survivors on the criminal sexual conduct statutory reform working group, and she's also the executive director of Unspoken Voices. Very good to have you here. Ms. Granda, please state your name for the record and give us your testimony.
Thank you, Chair and committee members. My name is Kylo Marie Granda. As it was already mentioned, I'm the executive director of Unspoken Voices, a nonprofit organization that really works to amplify the voices of victim survivors, anyone who's experienced power-based violence, whether it's individual or systems-based power-based violence. And it says my internet connection is unstable. Can you hear me okay?
Everything's coming through terrific.
Okay, good, thank you. So I've always been called to this line of work. I used to work, Senator Limmer and I talked about this. I used to work within the prison system as a volunteer chaplain, and advocacy has been something that I have just been passionate about my entire adult life. So originally coming into this line of work, I had previously worked with those who would identify as offenders. About 7 years ago, I was sexually assaulted myself by a colleague, and I lost everything, my reputation, everything I had worked for. My daughter and I were basically homeless. It was horrible. And it took 7 years to take that back and to kind of come back to a place of ownership and a place of power. And I don't mean power in the wrong way, but just owning my own power and coming back to that. And as part of that process, several years ago, I started talking to the legislature and meeting Senator Limmer. For the first time, I felt heard. In a way I had not felt heard before. It was at an amazing. I was just there with my service animal and my daughter, and I was just there to listen. And he saw me and he said, "Who are you?" And I told him, and he said, "No, come forward. Your voice needs to be heard." And so he gave me the chance to believe in myself again. And so I moved forward, and then I kind of turned into a pest, I think. And I was like, hey, Senator Limmer, I want to do this working group. It would be great, wouldn't it? It'll be wonderful. And it was the best experience of my entire life. I worked from January of 2019 to now on this. And I don't mean for it to sound pompous, but there's only 7 of us on the steering committee. I'm the only non-attorney, and I'm going to be very honest with each of you. There was a lot of conflict when we first started the group, but we were able to bring it together and able to say we want to help those who are most impacted by our systems, and that's something I know everyone on this committee believes. And for me, it was all encompassing. It's a wholesale. As we talked about what can we do for victims, it was also what can we do to not disproportionately increase our footprint, what we're doing for the individuals we're serving. How can we best serve them, knowing that today's victims might be tomorrow's offenders? So going into that, looking at how can we keep our numbers? We don't want to be flooding the prison system right now. So what can we do? Something Senator Latz said at that hearing 2 years ago was, working groups I don't know if they really work, or task forces, because they don't have people from across the aisle. They need combined and collaborative support. And so I went out and decided that I wanted to prove Senator Latz wrong. I like you, Senator Latz, but I wanted to prove you wrong. And I got defense attorneys on the group, some of my best friends now, actually. And so we really worked together to bring this forward. And I, in good conscience, have to say that the POR part of this is just as important as every other piece in here. It's important that the members that came to those meetings are heard and that their wishes are represented as well. And that's what I'm here doing today, is just making sure that the entire, I'm speaking on behalf of the defense and the prosecutors, and I'm sorry to be doing so and throwing so much at you, but there's a lot I want to carry forward. And in addition to this bill, I want to carry the POR forward. So that is my hope, and I just want to say thank you.
Thank you, Ms. Rhonda, and hopefully you can stick around for some questions.
Definitely.
Shortly. Very well. Next, we'll hear from Patty Wetterling. Ms. Wetterling, welcome.
Thank you for having me here. My name's Patty Wetterling. I've been involved with, the first sex offender registry law was named after my son, Jacob. It was designed with one goal in mind, and it was passed in 1991 in Minnesota. And that the goal was to, the belief was that sexual offenders always reoffend, and it was to be a law enforcement tool so that they could know when a crime is committed, who's done this before, and quickly, go after it to clear or investigate further. The name was changed to predatory offender in August 1st of 2000, and I think that's hugely significant. Sex offender registry. Now people believe that everybody on the register is a predator, and that they are safe because they can look up where these all live, and that's not true. It's simply not true. And in our case, Danny Heinrich, the man who kidnapped and murdered Jacob, would never have been on a list because he had no priors. So is it working? The question is it working? What's working about it? And what do we need to look at? It's been 30 years. Today we know more. We know more about those who commit these crimes, and they have actually a lower recidivism rate than people who commit any other crimes. So that's a total turnaround than what I was given at the time that we passed this law in the first place. The number of people on the registry keeps growing. Everybody's angry about sexual offense. I am too, but they just think that that's the simple solution, is throw everybody on a registry. What I'm here to talk to you mostly about today is the fact that we are putting children on a registry. Everything about that is wrong to me. At what point do you give up on children? They are not the same as adult offenders who go after children. They are not the same as predatory. Most of them are victimizing within a family or local friend network. When we put them on a registry, it's a life sentence because of the internet. You can't. I met once a 10-year-old who was at a treatment facility in Alabama, And, you know, imagine him going back to his middle school and he's on a sex offender registry. It's like there's no turning his life around. We are causing a bigger problem than we want. Children respond very well to treatment. Some of the language that we use when we talk about sex offenders is really harmful and doesn't apply to children. They are not mini perverts. They are not pedophiles. They are not, for the most part, predatory. And so we need to look at all of the language that's involved. Surveys, studies of young people at the end of their adolescence find that as many as 70 to 75% of the sexual assaults and abuse that they experienced were committed by children under the age of 18. That's a huge problem. Putting them on a registry is oversimplified. There's no one size fits all because everybody is different. The application of laws targeting adult sex offenders are counterproductive, and they do more harm than good when you apply them to children. There's so much we know. I chaired a committee for the National Center for Missing and Exploited Children on children with problematic sexual behavior. They don't even call them child sex offenders for those in the field who are working with these kids. We studied for a year. There's a lot of research. There's a lot of expertise that we need to be looking at in Minnesota so that we can offer these kids some help. While I was chairing that committee, I had a dear friend call from another state who was a blended family. They had a 12-year-old who was doing some sexual curiosity, experimenting with a 3-year-old in the family. Imagine that in your family. The mother of the 3-year-old was afraid to get the 3-year-old some help because of mandatory reporting. And then the 3-year-old's half brother or adopted brother would be on a sex offender registry. And so it delayed everything. This likewise, the mother of the 12-year-old didn't want to get the 12-year-old some help because of the fear of being on a registry. So both people and both sides of the victim and the person causing harm were harmed. So we're not addressing the problem in any way. In essence, there's research to show that kids on the registry, there's some lasting damage. Research from Johns Hopkins shows that children who are required to register as sex offenders are at a greater risk for harm, including suicide, higher rate of suicide, sexual assault, and sexual assault compared to kids who were not put on the registry. In essence, kids who are put on a registry have a higher rate of becoming victims of sexual assault. And is that what we want in terms of addressing that? These kids need help. And there are lots of programs across the country that provide multi-jurisdictional assistance to kids who have caused harm and need help. So I really think that the predatory offender registry, I don't like that word predatory offender because not all the people on a registry are predatory offenders. But anyway, the working group that you're proposing and talking about is hugely important to me. We need a balanced and evidence-informed response to children who are causing harm, and putting them on the registry is indeed assigning these children to a lifetime of very little chance of success.
Thank you, Ms. Wetterly. I am struck by how much we are constantly learning as we're going forward, and obviously need to adjust our policies and our laws in response to that learning. Please, hopefully you can stay around for any questions and answers toward the end of the presentations. Next, we'll hear from Katie Kramer, Violence Free Minnesota. She'll speak on survivor support and prevention grants. Ms. Kramer.
Thank you, Chair Mariani, Chair Limmer, and members of the Conference Committee on SF970. I'm Katie Kramer, Policy Director with Violence Free Minnesota, the Coalition to End Relationship Abuse. We are a statewide coalition with over 90 member programs who provide advocacy and services to domestic and sexual violence victims in all of Minnesota's 87 counties. I'm testifying today in support of the grants for crime victims that were included in both the governor's budget and the House Public Safety and Judiciary Omnibus bill at varying levels. We hope that your final budget target can, at a minimum, support increased funding for victim survivors and their families at the level of $6 million per year included in the House bill. And we know that the need is even greater. This funding is supported by each of the 5 statewide coalitions working to end violence and abuse: Violence Free Minnesota, MinCASA, as well as the Minnesota Alliance on Crime, Mending the Sacred Hoop Coalition, and the Minnesota Indian Women's Sexual Assault Coalition. For the past 2 years, we've been presenting information to the legislature on the needs of victim survivors around the state. We identified an additional $20 million a year of funding needs before the pandemic, and the gaps in funding around domestic and sexual violence have only been made more glaring during the pandemic. Our advocacy programs report record numbers of people reaching out for services with heightened levels of violence, complicated family dynamics, and enhanced mental health issues. Our request for funding covers a variety of needs for victim survivors and their families that include funding for community-based advocacy services for victim survivors of domestic and sexual violence, child abuse, and general crimes. Our member programs need to increase their levels of advocacy to meet the identified needs across the state. Prevention funding aimed at stopping the cycle of violence in our communities. Ending domestic violence requires an investment in prevention. With funding, we can promote community education and healthy relationship training with youth to prevent violence from happening in the first place. We also need to address repeat violence by providing funding for domestic abuse transformation programming, restorative justice, and other programs to change offender behavior to end the destructive cycle of violence. While Minnesota has never invested in domestic abuse transformation programming in the past, we are excited to hear discussions around this critical need. A financial investment into this work by the legislature can expand community programs that have long wait lists or are not available in many areas of the state. Finally, this funding request includes direct client assistance funds to allow survivors of crimes to have immediate access to safety and allow them to meet the basic needs of themselves and their children. Replacing broken doors, assisting with relocation costs, paying for uncovered mental health and healthcare costs are all critical components to safety. More than 68,000 domestic and sexual violence victims receive services from our advocacy programs each year. During the COVID-19 pandemic, domestic violence programs were on the front line supporting our most vulnerable community members. We are urging your support for substantial funding that will sustain and expand critical public safety operations for crime victim services in your final judiciary and public safety package. Domestic violence programs have a direct and immediate impact on public safety of Minnesotans. We need your continued commitment to prioritize the safety of survivors, their children, and communities across Minnesota. Thank you.
Thank you, Ms. Miller. And thank you, and thanks to the coalition of groups that came together and put together a very mature proposal for us to consider. Next, we'll hear from Chief Jeff Potts and Rachel Kohler on the timely processing of U visas. Chief Jeff Potts, welcome.
Thank you, Mr. Chair and members. As the chair said, my name is Jeff Potts, and I am the executive director of the Minnesota Chiefs of Police Association. We represent approximately 300 police chiefs and more than 150 command staff members across the state. I'm also here today representing the Minnesota Sheriff's Association and the 87 sheriffs across the state. And we're speaking specifically on the U visa portion of this bill today. Both associations fully support the U visa section of the bill, and we believe that this change would provide important clarity and consistency for law enforcement in issuing U visa certification documents. A large percentage of U visa recipients are victims of domestic violence, and certifying U visas is a key tool for law enforcement to protect those victims and hold the perpetrators responsible. The data collection will help the federal government ensure that the U visa program is not abused. And finally, we believe this bill will give victims more confidence to report their victimization and ensure a timely processing of these documents by our agencies. Mr. Chair and members, thank you for your allowing us the time to testify here today.
Thank you, Chief Potts. Thanks to the Chiefs Association, to the Sheriff's Association as well. And hopefully you can stick around as well. Rachel Kohler from Standpoint, Minnesota, also to speak on the U visa issue. Welcome.
Thank you, Chairs Mariani and Limmer. Members of the committee, my name is Rachel Kohler. I'm an attorney for Standpoint, a statewide nonprofit that provides legal advice and consultation to domestic and sexual violence victims in the state of Minnesota. My expertise at Standpoint is in immigration law. I'm speaking to you today as a supporter of the U visa bill in front of you, SF970, Article 5, Section 8. I want to start by giving a little background information on the U visa itself. It was created in the year 2000 through a bipartisan congressional action. The U visa itself, if approved, would provide temporary status to victims of crime. The stated purpose of the U visa is to strengthen the ability of law enforcement to investigate and prosecute cases of domestic violence, sexual violence, and human trafficking. The focus on these crimes in particular was intentional, as abusers of immigrant victims often use threats of deportation to maintain control over victims, to silence them, and to create a fear of law enforcement and the criminal justice process in general. The U visa was created to counteract these abusive tactics and to encourage immigrant victims to come forward and trust that their immigration status will not be a barrier to accessing protection. Now to the bill at hand. The provisions in this particular bill are limited and are reasonable. As was already described, the bill requires a timely processing of U visa certification requests, the creation of an agent to handle the processing of these requests and implement language access protocols, and to prohibit the disclosure of a victim's immigration status unless disclosure is otherwise required by law. But what it doesn't do is create new rights under immigration law, and it still requires a federal immigration agency to determine whether U visa should or should not be granted. But what it signals to immigrant victims throughout the state of Minnesota is that anyone, regardless of immigration status, should feel safe to report crimes committed against them, and that reporting a crime and cooperating in that investigation will not in and of itself trigger a deportation. To drive this home, I'm reminded of one of the very first cases I worked on at Standpoint. The client was a victim of domestic assault, having been pushed to the ground and threatened with a knife for defending her daughter by her daughter's boyfriend. This client reported the crime to police and cooperated on the scene, despite being very nervous to do so. The client had been told by this perpetrator that her lack of immigration status made her insignificant, that no law enforcement officer or judge would ever believe her because she's not a US citizen. However, this client was provided with a U visa certification by law enforcement, signaling to her that it was safe to come forward and that her immigration status would not be used against her. The certification also was a signal to law enforcement that this victim promised to continue to be helpful in that investigation and prosecution. The client participated in several follow-up interviews with law enforcement. In the end, in this particular case, the perpetrator was pled guilty to a felony level offense without a trial. I urge you to recognize the value in a bill like this one, that it's a powerful tool for law enforcement to encourage the reporting of crime against all residents of the state, regardless of immigration status, and to encourage full cooperation and participation of immigrant victims. Thank you for your time.
Thank you, Ms. Kohler. If you could stick around too, I'd greatly appreciate it. Next, we'll hear from Nicole Matthews, Executive Director of the Minnesota Indian Women's Sexual Assault Coalition and Vice Chair of the MMIW Task Force, and she'll be speaking on the missing and murdered Indigenous relatives provision in the offer. Welcome, Ms. Matthews.
Thank you. Thank you, Chair Mariani and Chair Limmer. Buju and Dinaway Maganang, Nicole Matthews, Jagadashimon, Maridu Baneshikwe Indigo, Migizin Dodame, Gawa Babaganakaj, and Dunjaba. Greetings, relatives. My English name is Nicole Matthews, and my Indian name is Spirit Bird Woman. I am Eagle Clan, and I'm from the White Earth Band of Ojibwe. I'm truly honored to have the opportunity to speak with you today about the need for a missing and murdered Indigenous relatives office. I am the Executive Director of the Minnesota Indian Women's Sexual Assault Coalition, which is a statewide tribal coalition and a national tribal technical assistance provider. Our coalition membership spans the entire state and includes individual and organizational representatives from all tribal communities and includes urban representation as well. In addition, we provide technical assistance to tribes and community organizations across the country who are addressing both sexual violence and sex trafficking. I was also one of the interviewers for our research on prostitution and trafficking of American Indian and Alaska Native women in Minnesota, where we interviewed 105 of our Native sisters about their experiences being used in prostitution and trafficking. One of the things that we heard from many of the women we interviewed was that they knew of someone who had been trafficked and they had never seen nor heard from them again. We heard story after story of the violence and invisibility they encountered on a daily basis. One woman said that a sex buyer told her, "I thought we killed all of you." This is the same violence and invisibility that many of us encounter on a daily basis. We are Indigenous to this land and we deserve better. I am honored to serve as the Vice Chair of Minnesota's Missing and Murdered Indigenous Women's Task Force. Through the work of the task force, we have learned some heartbreaking statistics. In Minnesota, Native women and girls represent just 1% of our state's population, yet we represent 8% of the murdered women and girls. In addition, from 2012 to 2020, in any given month, there were anywhere from 27 to 54 Native women and girls missing. Each one of these numbers represents a person, a mother who will never come home to hug her children, a daughter who leaves a hole in her mother's heart, a relative who we will never forget. In 2016, Rose Downwind was missing and found murdered by her partner. That same year, we lost Tanya Skinaway Sam, who was also murdered by her partner. And on January 29, 2018, we lost Lene Strong, who was murdered in St. Paul. Jojo Boswell disappeared in July 2005 at the age of 19. Sheila St. Clair disappeared from Duluth in August 2015. And April Geyer has been missing since 1998, and she left behind a son who was raised by his grandmother. These are only some of the stories, and there are many more stories that are yet to be told. Stories that we haven't heard in the media, stories from our Indigenous trans sisters, stories that have been forgotten, and some that have been deemed unimportant. With the creation of this office, we will have dedicated staff and resources to work collaboratively to address this issue. We must continue the commitment that was started 2 years ago when you passed a bill to create the MMIW task force. None of us on that task force set out to just create a report and go back to work as usual. We've worked together for nearly 2 years, bringing tribal, state, and community partners together for a shared vision of understanding and addressing the crisis of missing and murdered Indigenous relatives. These stories are not just numbers for us. They represent a loss to our community and our families, and it is time that we continue to acknowledge the responsibility of the Indigenous relatives on whose land we sit today. I said this before when we were trying to pass the bill to create the task force, that Minnesota has long been a leader on the issues of gender-based violence. And I know that creating this office to address this issue is a great way to continue that legacy. Miigwech.
Thank you, Ms. Matthews, and thank you for making visible the very real stories of Indigenous women, Indigenous people here in Minnesota. Next, we'll hear from Suwana Kirkland, Director at Dakota County Community Corrections, and she'll speak on the Task Force on Missing and Murdered African Women. Ms. Kirkland, welcome.
Thank you so much, Mr. Chair. Good afternoon, committee members. As the Minnesota president of the National Black Police Association, as well as the national vice chair of the very same organization, we support and encourage this bill. This bill will allow the support and collaboration that only a task force can provide. This task force will allow recognition and the efforts to be placed as a priority for law enforcement and for all community members to support the families, to receive the support, to receive the dedication that the victims deserve. It's our thoughts to assemble a diverse task force reflective of the communities in which many of the victims live, work, and invest in, and often many who were taken so violently from. This task force will expand and further equip law enforcement to keep open lines of communication with communities, elected officials, state, county, and city agencies. As a mother, I hug my daughters a little tighter now. We know our daughters, our wives, our sisters, our aunts, our girlfriends, our coworkers are in far more danger today than they have ever been in the past. Violence is everywhere, but violence has gone unnoticed, undocumented, not investigated, not prosecuted, and has not been a priority for many African-American women and girls. In the meantime, they're still referred to as wanting to be grown, wanting to be on their own, wanting to see the world, and often just called runaways, and that they will be back. We know many of them never come back. They don't come back, they're not found, or they are found and they're brutally victimized. When and if investigated early and taken seriously by law enforcement, these women and girls would still be alive today. These women and girls are families, they're community members. Again, they're coworkers, sisters, daughters, nieces, and wives. It's our responsibility, and it's our responsibility now. This bill, this task force will allow appropriate tracking and collection of data to look further at the violence against African-American women and girls, as well as missing. This task force will look at the policies and the institutions that surround coroner reports and practices. This task force will help with appropriate investigations and prosecution of crimes of gender violence against African-American women and girls. This task force will address the necessary actions to reduce the violence against, again, African-American women and girls. These measures and actions are needed, and they are needed now. We sit as we lose more sisters, more daughters, more wives, more friends to violence. Thank you so much for your time.
Thank you, Director Kirkland. And if you can stay around for a few minutes, we'd appreciate it as well. Next, we'll hear from Sam Parmakar, State Government Director with the Minnesota Student Association, who will speak on the last provision, the immunity for sexual assault victims and helpers. Mr. Parmakar.
Thank you so much, Chair Mariani, Chair Limmer, and members of the committee. My name is Sam Parmakar. I'm the State Government Director for the Minnesota Student Association, the undergraduate student government at the University of Minnesota, Twin Cities. I'm here today to ask you to adopt Article 15, Section 26 of the House bill, which is also the third provision in the House's offer, which extends Minnesota's Good Samaritan laws to cover instances of sexual assault. This bill is modeled off of two existing statutes, 340A.503, which grants alcohol amnesty protections to minors experiencing a medical emergency, and 604A.05, the Good Samaritan drug overdose law. Together, these statutes provide limited immunity from limited immunity from possession and consumption charges to an individual who suffers a medical emergency while under the influence of drugs or alcohol, as well as up to 3 bystanders who contact emergency services on their behalf. This is, of course, predicated on the notion that when someone's life is on the line, we think it's more important to make sure they get the care they need than it is to charge low-level drug and alcohol offenses. While these laws offer protections in cases of medical emergencies, the immunity provisions do not extend to instances of sexual assault, which is what the language in the House bill seeks to accomplish. This is a really important step to ensure that survivors feel supported when they come forward to report sexual violence. As we know, there are already so many institutional and cultural barriers to reporting an assault. This bill alone won't fix that problem, but it does send a strong message, particularly to young people, that our institutions take sexual violence seriously. And believe me, there's a clear need for that message to be heard. According to 2019 data from the American Association of Universities, 54% of college women who did not report their sexual assault listed the fact that they were under the influence of alcohol as a reason for not coming forward and reporting. It's safe to assume that the statistic is unacceptably high for non-binary students as well. But it's not just sexual assault prevention advocates that recognize the benefit of these protections, it's law enforcement as well. In 2018, the University of Minnesota Police Department implemented a department policy providing medical amnesty protections to survivors, and in 2019, the Minneapolis Police Department followed suit. Of course, sexual assault doesn't just happen in Minneapolis. Every Minnesotan should be entitled to these important protections if they experience a drug-induced assault. Student advocates have been trying to get this language passed for 4 years now, but the work has taken on renewed importance recently. When the Minnesota Supreme Court ruled that voluntary consumption of a substance does not constitute mental incapacitation, it laid bare how our laws fail to support survivors. Everyone on this committee recognizes the urgency of making sure that those assaulted while intoxicated can seek justice, and the language in this section is a key component of eliminating barriers to reporting. I want to note that this bill was unanimously passed by the House Public Safety Committee earlier this year and has had a bipartisan list of co-authors in every session it's been introduced. In closing, the goal of this legislation is simple: to encourage people to help one another. When someone is sexually assaulted, we want to make sure there's absolutely no hesitancy for them to come forward and seek help or for others to help them. They shouldn't have to weigh the importance of reporting with concerns about low-level substance crime. This language really just closes some of the gaps in our existing law, and I hope you all can support it today. Once again, thank you for the opportunity to testify on this bill. I urge you to support it, and I'm happy to answer any questions.
Very well. Thank you, Director Parmakar. With that, members, that concludes the testifiers on several of the provisions before us. And so I'll open this up for questions and comments from conferees. Senator Ingebrigtsen.
Thank you, Mr. Chair. I don't see my hand going up, but oh, I got it now. Okay, thank you. Well, listen, I want to thank all the presenters today for the work that they do in trying to prevent crime against children and women. I specifically want to ask and comment with regards to Patty Wetterling. I've known Patty Wetterling since the day she and her husband reported Jacob missing. I was about mid-career of my law enforcement career, and knowing a real good friend of yours, Ms. Wetterling, Michael Corkill Baumgars, was actually out putting up signs, and I can't even imagine what you went through for the years and years of that investigation going on. I did, however, have an opportunity with my chief, and I believe it was my county attorney, to travel to the Center for Missing, I believe it's Missing Children. Help me out, Ms. Wetterling, if that's not the actual call or name of it.
Yeah, missing and exploited children.
Right. So at the center, and I believe it's in Memphis, and members, if you ever get an opportunity, if it's still there, which I have no reason to believe it's not, Patty was very instrumental in getting that going, and it was amazing to me, the facial reconstruction and the amount of work that they were doing there. That was back then. I can't even imagine what you're able to do and capable of doing now. But so I thank you for your tireless work in memory of your horrible loss. Ms. Wetterling, can you just comment one more time, please, on the, I didn't catch all of it, but you said the lower recidivism rate. Was that in regards to juveniles? Was it in regards to adults who are offenders? Can you answer that a little bit?
Yes, I have a whole volume of research papers, and I can get you the exact citation of that. I think that was a generalized comment that, you know, it countered everything that I had known or believed in that we were told when we passed sex offender registry in the first place. But for sure, I can honestly promise you that children have a very low rate of recidivism because they're kids. They need to be taught proper boundaries, proper sexual development, and kids are sexualized at really young. I mean, they're born sexual beings. There's a person on our committee who had established a treatment program for preschools with preschoolers with problematic sexual behavior. So this is something that it's hard to talk about. We don't talk about normal, healthy sexuality in our culture in the first place. And so these kids get many ideas from the internet, from TV, from, you know, modeling the worst behaviors, the ones we don't want them to have. And then when they get caught, we owe them an opportunity to change. And I heard you earlier concerned about dollars. To me, this is a huge dollar savings. If we can turn these kids' lives around at young ages, we're not going to be monitoring and rearresting and having them on a registry for 10 to 15, 20 years.
Mr. Chair.
Senator.
Thank you. Thank you, Paul. And again, I do know that, you know, trying to break that cycle, trying to do that at an early age is work, I think, well appreciated, and it's just very valuable. And you know, we've never dealt with that. I shouldn't say we never have, but it's fairly new on the horizon of trying to prevent this horrible crimes from happening. So I think you mentioned that you didn't think they should be on at a young age be on a list, and I agree with that. I just think that would be just absolutely devastating, and so I hope I can be of some help with regards to that, and because we all love our kids, and we certainly don't want to see them go through any horrific things, and nip things early in the bud, if you will. It's an old saying, but nevertheless, get it early so we don't have to deal with it later, and we would be saving a lot of our resources. So thank you again for coming, and thank the rest of you as well. Thanks.
Thank you.
Thank you, Senator Ingebrigtsen, and I wholeheartedly agree with you. Representative Miller.
Thank you, Chair Mariani. I'm not going to talk about that last subject because that was not what I came to do, but I hope this working group does come to be, and I want to share with them some perspective that we have out here in my area. But I'm going to be talking about the human trafficking portion of that. And I won't go deep into this, but Senator Latz, you warmed my heart when you brought the Bible into the room. In Isaiah 55, it talks about how God's word is not returned void. So thank you. I think we can solve a lot more issues in our state if God were in the room in our government. But on this on the human trafficking, so just a real quick perspective, in 2015, when I was first elected, then Chair of Health and Human Services Finance, Matt Dean, came to me with a bill and said, will you carry this? I didn't even know what carrying a bill was. But it was a straightforward funding bill for people that have been around this long. The Safe Harbor No Wrong Door was passed in 2011, unfunded, and they were funding it a little bit each year after that. And that's ostensibly what I was going to be doing. And at that time, I thought very important work, but I never expected for this to become one of probably the issue that I've championed most in the state of Minnesota, because the people in this room probably know this, but I always tell people the bad news is that in Minnesota, human trafficking, particularly for sex trafficking, is a huge problem. But the good news is that Minnesota is one of the states that has really taken not only huge leaps forward in dealing with it. We have people from other countries coming to see how we do things here, but we continue to press forward with us. We didn't just pass something and then move on from it. I asked Chair Representative Pinto to join on because he and I came in at the same time, and when I was in the majority, if you will, I kind of was able to move things because I was in the majority, and now that his party is in the majority, he's been doing it. But we've been working together on both the law enforcement side of this and also the human services element to this. And we've really worked side by side in a lot of this, and I know a lot of you have as well. But the bill that's before us that I want to bring special attention to, and I asked, I hope it's okay, Mr. Chair, but I asked Representative Pinto to kind of tell, as we progress forward in the good work that we've been doing in this state, we have a need for this coordinator. And because it's his bill, I asked if Representative Pinto could kind of say why it is that we came to this point and why we need this coordinator at this point. Is that okay?
That is okay. And I do see Representative Pinto is here. He carried this provision a couple of years ago as well. So this idea is not, like off the cuff. It's I know it's been carefully considered before, but Representative Pinto to Representative Miller's inquiry.
Thank you, Mr. Chair, and thank you, conference committee members, for allowing me to join you. I was on this committee 2 years ago, and I wish you the best of luck in your work. As Representative Miller mentioned, he and I came in together, I guess, in the 2015 session. And for folks who don't know, I work as a prosecutor outside the legislature. And at that time, I was the director of training and protocol development statewide for the safe harbor system. So Representative Miller made a mention of that. That's our system in our state to say that young people who are being sexually exploited should be directed to the child protection system to service and support rather than being treated as criminals, which they had been up to that point. And as part of that law change, our state put a lot of changes into place, including a lot of work around training law enforcement, training others, putting protocols in place. So that was my work for a number of years, being the statewide director of that training and protocol development work. As Representative Miller alluded to, it's kind of an odd situation that he was a conservative Republican in his first term, pushing for money for services and support and housing and things. And I'm the progressive Democrat. I'm pushing hard to investigate and prosecute and hold accountable traffickers. And it was a really good collaboration. So members, in front of you, you've got the proposal for a coordinator of investigations of sex trafficking. And I want to make sure to just set the context that in that year in 2015, I had the thought that, we're training officers around the state, but these cases are complicated. They take a lot of time. They take a lot of expertise, and we don't have the support for them. And so I came up with the idea of having state funding for grants to support investigation of trafficking. Then Chair Tony Cornish in the House heard that proposal and ran with it, which is great. Senator Latz in the Senate as well, and glad to have him here. And so that really has expanded from a pretty small amount to now we've got $1 million a year going out to multiple task forces around the state. Members, as part of that work, it seems to me, as the person who founded that, and I should note, by the way, right over my shoulder when I was presenting to Chair Cornish was Representative Miller, and it's been a partnership all the way along. We really need to have that work around the state have some sense of coordination. Not that there's somebody who's overseeing the actual day-to-day work investigating cases, but what those task forces do a lot of, members, is they do training, they do community awareness work. There's a lot of protocol development work. I've got this protocol guidelines that we worked on that I helped to draft, and they've got people working on those. All that work is taken away from the work of investigating and actually handling cases. So members, I really want to highlight for you the need that as we're investing as much as $1 million a year, and I know the House is proposing to spend more, which I think is very necessary, but there really should be an oversight position in the Office of Justice Programs to coordinate that work and oversee that work. And as I say, to take off the plate of some of those task forces, the work that's not about identifying and investigating trafficking, but is about that kind of other broader systems work. So really, thank you, Representative Miller, for highlighting this. And members, I really would urge you to include this in whatever ends up passing out of the committee. And thank you, Mr. Chair.
Thank you, Chair Pinto. Representative Miller?
Yeah, thank you, Mr. Chair. I won't take much more time. I just want to put really kind of a frame on this. The state's been doing good work, and this is one specific area to where it's shown growth. There's some other areas as far as when it comes to safe harbor, no wrong door. We have kids. The good news is we're pulling kids out of trafficking, but then we need a place for them. So there's stuff in HHS that we're dealing with too. So I guess the message I want to tell people is Minnesota's doing a really good job on this. But as you know, if you do a good job, it does require more resources. And I hope you're hearing from a very fiscally conservative person who doesn't like to spend a dime on anything that we don't need to. That this is the right type of investment for the state of Minnesota. I don't like we're using the word investment all the time even, but this is truly, we have seen improvements in this area in our state because of this work that we've been doing over the last several years. This is the logical next step. The law enforcement piece of this, where we're increasing penalties, proposed increased penalties on the Johns, is an important piece of this. So I hope we can do that too. But Members, I just ask that we can figure out a way as we move forward to get this into law. Thank you.
Thank you, Representative Miller. We have one more, Representative Muller, but before I turn to Representative Muller, I just want to ask a couple of very quick questions, and hopefully the answers can be pretty concise. One to Ms. Matthews of the Missing and Murdered Indigenous Relatives provision. There's been a little bit of conversation in this conference committee as we explore what's the best, way in which to carry out the recommendations of the task force. And one side of the debate says, we can have existing law enforcement do that work. The other side says, no, we need an office to direct some of that work. It's a fair debate, but I'm wondering if you could just quickly offer us some advice on why we need to establish an office to carry out and oversee the recommendations that came forward from the task force. Ms. Matthews.
Thank you. So, I really believe that an office is needed because it can coordinate these efforts. We can pull the data together. We can work with our tribes. That office can work with the tribes and the state systems and our law enforcement and prosecution, and pull all of the partners together to really have a coordinated effort. And sometimes, when we don't fund things, it really goes to show what the level of importance is. And so I think, having this office would really show how important we believe this is, that we want a coordinated effort in Minnesota, that we want to pull all these partners together. And I think we are perfectly positioned here in Minnesota to be able to do that.
Thank you, Ms. Matthews. And I'd love to dig in more, but time is pressing. I'm wondering, Ms. Kramer, if you can just very quickly tell us, one of the things that struck, I think, the House members when we heard the proposal on the survivor support prevention grants, I was stunned, was the huge need that currently exists and how we're not able to meet that huge need. And that's true all across the state, but it seemed to be particularly acute in greater Minnesota. I wonder if you can just tell us quickly, Ms. Kramer, just a little bit of information about that, about what the need is in terms of seeking support from our different parts of the state for survivor supports and prevention grants.
Sure. Thank you for the question, Chair Mariani. As you mentioned, the needs are incredibly great, and the current funding that we have is unfortunately woefully inadequate. A great example of that, so just as sort of background, many of our member programs are funded by the Office of Justice Programs, have budget line items for direct client assistance, but the money is, again, the money available is not sufficient, and it takes away from other program needs. So one example of that is a member program, Someplace Safe, which is a domestic and sexual violence program serving 9 counties in West Central Minnesota, used up their OJP budget line item in the first 4 months of their 24-month grant period. They also have not filled an open advocate position as they're using those salary savings to continue to meet the needs for direct assistance. So it's really, the needs are incredibly great. They were great, again, before the pandemic, during the pandemic, and they're continuing to be great, the needs. So we appreciate any support that the committee can offer us.
Thank you, Ms. Kramer. Perhaps you could provide committee members, I know that you in testimony actually quantified what some of those requests have been and what the unmet needs. If you could forward that to conference, I think that would be very helpful. I lied, there is someone else. I'm going to call on Chair Limmer, and then I'll ask Representative Muller to close us out. Chair Limmer.
Thank you, Mr. Chairman. I had a question for Representative Miller. Representative Miller, you made mention when you were talking of sex trafficking that so far our efforts have been very successful. And so could you tell me how many arrests have been made in recent years regarding sex trafficking and how our policies have improved the investigations and the arrests?
Yeah, Chair Limmer, I I may phone a friend because I couldn't tell you the numbers. Actually, I'm guessing Representative Pinto, if he still can answer that. But I can address, I know that the convictions have been strong on the traffickers. We've had some very successful things, particularly up in Stearns County. I think some other areas as well in the Twin Cities that Representative Pinto can point to. We haven't been, in my opinion, successful enough in dealing with the Johns, the people that are purchasing these girls. That's a longer discussion for another time. That's why I think that other piece of the bill here, where we're increasing penalties and kind of strengthening some of that, is going to be an important piece. Can you ask Representative Pinto? Might be able to give you those statistics. I couldn't give them to you at this time.
Representative Pinto to Chairman Limmer's inquiry.
Thank you, Mr. Chair, and thank you to Chair Limmer. Mr. Chair, I don't have the specific numbers in front of me either, but what I can provide just as a bit of context is that from 2015 for about a year and a half, 2015, 2016, we trained, and I personally trained about 2,000 officers around the state of the 10,000 officers. Then we had videos and other pieces. We had a huge effort that went into identifying and investigating trafficking. And then it was around that time that this funding went out. It's been increasing over the last number of years. So right now there are multiple task forces around the state, but there's so much more that is needed. So what I'll say is that I know that arrests have continued to be steady and convictions as well. The case I was involved in, 36 years and 40 years for 2 traffickers. But I will note that if in fact it were the case that you would see any slowdown in arrests, because again, Mr. Chair, Chair Limmer, I don't have the data in front of me. One reason for that might be that in fact we have not kept up in the same way, because of course arrests are often going to be about having those street officers who are going to notice things going on when they do whatever the situation may be. And so what I'd say is I believe that the numbers have continued to be steady, but if you've seen maybe a drop off somewhat in the increase, in part that's because of our shift of not having had that same approach. The advantage of the coordinator position that we're looking for is that way we make sure that we in fact have training going on around the state, both at the patrol officer level and also at the investigation level as well. And certainly happy to follow up with you as well too with specific numbers. And thank you, Mr. Chair.
Chairman Miller.
Mr. Chairman, I'm always, as you might know, I'm always looking for results, especially in the early phases as we get into some of these issues. Thank you, Representative Pinto, for giving me that advice. If you have any detailed information, if you could find it, please send it my way. Appreciate it. It's been a while since you and I have talked, so we should probably connect sometime soon. One other question I had on the missing murdered Indigenous relatives office. The word was said that I picked up the word coordination with law enforcement, and I'm trying to determine what that actual role would be. Is it victim support coordination and how it intersects with local law enforcement, or is it actual investigations? Are they going to be participating in that? And are they going to be involved with tribal police, local police, or BCA? Where, if you can put a little more meat to the bone on that, I'd like to know a little bit more about what the role or the mission would be of the office as it affects coordination with law enforcement.
Let's begin with Ms. Matthews. Ms. Matthews.
Thank you. It's a great question. On our task force, we have both tribal law enforcement and local law enforcement, state and county. And so really, I think the role within the office is going to be coordinate with local law enforcement who will be doing the investigations, or tribal law enforcement. But really, what we did within the task force was to look at what are the policies and the practices that each of us has in our respective roles that addresses or maybe misses addressing this issue. And so for us, from an advocacy perspective, what is it that we need to look at that we can do better? What is our role in that? Law enforcement, what are the practices and coordination between tribal and local law enforcement? And so, the office, I think, could really be a place to pull people in to really take a better look and to be able to address some of the policy issues and some of the coordination between those entities that are responding. I don't see the office necessarily as the office that is responding themselves, but more coordinating efforts with local and tribal law enforcement.
Chairman Limmer?
I'm done. Thank you.
Thank you, Chairman Limmer. I do like the call for collaboration in the language, and I suspect that was powerfully intentional on the part of the task force.
No, Mr. Chairman, on that point,
yes.
I'm just a little concerned about how we intersect civilian roles with law enforcement roles and how the gathering of evidence might be determined. There's certain legal procedures to follow up on evidence and follow up on leads. In the desire to participate and point in directions, if that's the role of the office, it seems like it's a little more expanded than that, with more of a community outreach and community involvement. But I'm just a little concerned that do we overstep in this? I think we have to be cautious. We have to not overstep into a different lane from a civilian role to kind of a law enforcement role. And I'm just trying to get a little more definition on that. That's all.
No, it's fair, Chairman Limmer. We may want to dig in a little bit more if time allows in the near future. I do note that the office will be within the Department of Public Safety, so it's not standing out apart from our state law enforcement agency. I also know that the task force itself had a combination of law enforcement and community and tribal folks as well. So it might be good to hear their perspectives on your question, Chairman Limmer. With that, I'm going to close this out and ask Representative Moeller to do that either with questions or comments or both, or summations or whatever you think is helpful, Representative Moeller.
Thank you, Mr. Chair. And I don't have any more questions, just a few comments, especially those that are relating to trafficking and the questions that just came up. Those are really good questions. And I also think that when we think about trafficking and when we actually think about sexual assault, domestic violence, all of these kinds of person crimes, we need to think about prevention. That, we can look at the end results and we can look at data on arrests and convictions. But we also need to look at how do we prevent these crimes from even happening in the first place. And there's a lot of really great stuff in our bill, not just in the provisions with us today. I mean, certainly the Missing and Murdered Indigenous Relatives position, the Missing and Murdered African Women's Task Force, like those are all things that can deal with prevention. But we also have a lot of things on the correction side, too, of our bill that deal with prevention. So I just wanted to point out that I think that that is all really important work. In addition, I just want to thank all of the testifiers today, and especially those survivors who have continued to come forward year after year and ask for change at the legislature. They share these traumatic experiences with us. They know that it's not really going to impact their case, but they do it because they don't want the same thing to happen to others. And we've passed a lot of good things, even in the short time I've been in the legislature, as a result of them speaking out. So it makes a difference, and we've heard you, and we continue to hear you. And I just want to extend my gratitude to them for that. One of the bills we didn't hear testimony on today, because it is in both omnibus bills, is the elimination of the statute of limitations in sexual assault cases. And I just wanted to close my comments with a quote that I remember from the conference committee we had a couple years ago on that issue, where we haven't passed that yet, and I'm really hoping we can do it this year. And one of the survivors in conference committee said, sexual assault is a crime that silences people. It silences its victims. So why do we have laws in place that further silence victims? And that's really stuck with me, and I think that's important. And just part of our message here today, that we hear you And we're going to do all we can to get these bills passed. So thank you, Mr. Chair.
Thank you, Representative Mueller. Good way to close us out. I'm always struck by the notion that our laws do reflect a deep commitment to our morals. And I think you captured pretty concisely one of our, I think, wisdoms in our society relative to our moral posture of giving voice and allowing voice to be heard. Very well, thank you. I want to thank all the testifiers today. Terrific work, thank you. I want to thank all the conferees and committee members for their honest inquiries and interactions here today. We're going to move on to the second part of the agenda. And at this point, I'm going to ask the chair of our judiciary committee to assume the digital gavel. I have to figure out how to send that digital construct to you, Chair Becker-Finn. But I would like
Bitcoin, Mr. Chair. I use Bitcoin.
What's that?
Bitcoin.
Bitcoin. All right, I still can't vision it, but I'll figure it out. Chair Becker-Finn, if you would be so kind as to take the gavel from here and then direct us in reviewing the judiciary provision.
All right, thank you. Thank you, Chair Mariani. I have received the virtual digital Bitcoin gavel, and thank you for passing the gavel over as we walk through these judiciary provisions. We're going to walk through it really quick. We did email this out to folks ahead of the committee, and it is also posted on our website. But I'm also going to share it here for folks as well as we walk through. And then we'll do the same as we did at the beginning with the crime victim provisions as well, to have nonpartisan staff walk through with additional information. So number one on the list is reducing or waiving traffic and criminal surcharges. That is a bill carried by Representative Frazier and Senator Latz. Civil asset forfeiture reform. Extending certain post-conviction relief petition deadlines. I should also add that forfeiture reform, Senator Johnson is the Senate author, and Senator Abler is the author on extending certain post-conviction relief petition deadlines. Number 4, exempting filing fees by tribal representatives. Number 5, disposition of fines and fees for Ramsey County. Number 6, authorizing public defenders to apply for an interpreter services from the court. And just trying to move this down. There we go. Number 7, increase in interpreter pay. Number 8, crimes motivated by bias. Number 9, the Department of Human Rights policy bill. Number 10, Preventing Pay Discrimination Act. That's something that's passed off the House floor. Number 11, banning housing discrimination based on public assistance. And number 12, penalty for noncompliance with state equity and inclusion contracts. And with that, I am going to pass it over to our nonpartisan staff to walk through with more detail. I believe Ben Johnson is first up to walk through these provisions. Mr. Johnson, please go ahead.
Madam Chair, members, thank you. I'm going to walk through the first 8 provisions here. The first one deals with reducing or waiving the traffic and criminal surcharges. Those provisions all appear in Article 5. First one is on page R2 of the side-by-side, and that requires the uniform traffic ticket to notify recipients that they may be required to pay the surcharge. On page R3, section 5 contains the language that's required to be printed on the uniform traffic ticket that informs recipients that the cost of the summons may be waived on a showing of financial hardship. Also on page 3, this is section 6, it allows courts to reduce or waive the surcharge imposed on criminal and traffic offenders based on their ability to pay. And then on page R4 of Article 5, this is section 7. It requires the court to consider a defendant's ability to pay, including the hardship payment would place on the person's immediate family before imposing a fine, fee, or surcharge. The section includes 6 factors for a court to consider in making that determination. The requirement does not apply to a violation that's listed on the statewide payables list if the person does not request a hearing. And the section is effective July 1st, 2022. The next provision on the list is the forfeiture provision. This appears in 3 areas in the bill. The first 2 are in Article 1 on page R5 in Section 11, that's line 6.22. There's an appropriation of $64,000 in fiscal year 22 and $30,000 in fiscal year 23. That appropriation is to the state auditor for costs associated with forfeiture reporting. A second appropriation, also in the Article 1 side-by-side, this is on page R12. It appropriates $24,000 in fiscal year 22 for costs for technological upgrades required for generating forfeiture notices. The bulk of the policy appears in Article 9. Article 9 makes multiple changes to Minnesota's forfeiture laws. I believe the Senate has heard this bill on an informational basis, so I'm not going to go in through section by section, but it makes changes related to DWI forfeiture, controlled substances forfeiture, sets some limits for the types of property that can be forfeit, makes changes to the innocent owner claims, how to make an innocent owner claim and how that must be heard, and it attempts to reduce the burden on those innocent owners. It also requires law enforcement agencies and prosecuting authorities to report on their forfeiture and on their use of money obtained through the forfeiture. Madam Chair, I'm going to move to item number 3. This relates to the post-conviction relief petition deadlines. The first piece of this appears also in Article 1 on page R5. It's an appropriation of $187,000 in fiscal year 22 to the state public defender for contract attorneys to represent individuals who file post-conviction relief petitions. The bulk of the policy is in Article 4. In Article 4 on page R5 of the side-by-side, and I should note this was on page R5 and would be in R5 if you have a booklet most likely. Article 4 has been replaced. There was a missing provision. If you're looking online, we're actually on page R6. This is section 6. This section establishes an exception to the 2-year limitations period on filing a petition for post-conviction relief for a person in immigration removal proceedings when the proceedings are the result of a conviction that was obtained by relying on incorrect advice or without advice from counsel on immigration consequences. The fourth provision relates to exempting filing fees by tribal representatives. This is also in Article 4. Again, this is the piece that was actually omitted from the side-by-side. If you're looking online, this is now on page R3 of that side-by-side. It's section 3 of the House bill in that article. This section provides that a federally recognized American Indian tribe and their attorney can appear and file documents without paying a filing fee if the case they are participating in is for child support, paternity, civil commitment, public guardianship or conservatorship, or juvenile court or child protection matters. Moving to item 5, this relates to the disposition of fines and fees for Ramsey County District Court. This is in Article 4. Again, this was originally on page R4 if you're holding a binder. If you're looking at the version that's online, it's on page R6. This is section 5 of the House. It amends the distribution of fines and penalties and forfeiture that is collected by the court administration by providing that as of July 1st, 2022, every municipality or subdivision of government within Ramsey County shall receive 2/3 of the money, with the balance going to the general fund. Currently, those municipalities receive 50%. Item 6 on the list authorizes public defenders to apply for interpreter services from the court. Current law permits appointed counsel for an indigent defendant to apply to the district court for certain services necessary to provide an adequate defense. There's been some dispute about whether out-of-court interpreters meet that qualification. Court of Appeals decided a case in 2019 and found that court-appointed attorneys cannot apply to the district court to pay for interpreters used in meetings that take place outside of the court. Supreme Court did not review that issue as there was a plea entered before they had the opportunity to consider it. This change would provide that court-appointed counsel may file an application with the district court to pay for interpreters who are used in meetings that take place outside of court. Item 7 on the list relates to interpreter pay increases. This appears in Article 1 on page R4 of the side-by-side. provides that $400,000 each year are to increase hourly fees paid to qualified, certified, and uncertified interpreters. Madam Chair, that moves us to item number 8 on the list. This includes a variety of provisions related to bias crimes. The first provision appears in Article 1. It's an appropriation to the Department of Human Rights for costs, including those for collecting and reporting on crimes of bias. The next provision appears in Article 6. This is page R2 of the side-by-side in Article 6. It directs the commissioner to solicit, receive, and compile reports from community organizations, schools, and individuals regarding crimes that members of the community believe are motivated by bias. It also directs the commissioner to work with the Board of Peace Officer Standards and Training to develop training materials and standards for peace officers. The next few provisions are in Article 10. The Article 10 side-by-side on page R6, Section 8 of the House language. This amends the requirements that peace officers report crimes motivated by bias to specify that the crime may have been caused in whole or in part because of the victim's actual or perceived status. It also specifically includes the victim's gender, sexual orientation, and gender identity in the categories of bias, and expands bias crimes to include crimes against people who, when those crimes are committed because of their association with someone based on their actual perceived bias category. In Article 10 on page R8, Section 12, this amends the requirements on the post board. They no longer are required to prepare a training course. Instead, they're required to approve a list of training courses to assist officers in responding to and reporting crimes motivated by bias. This section also makes some conforming changes to reflect these new additional categories of bias that I just described, and directs the board to review an approved list of courses every 3 years and to consult with the Commissioner of Human Rights in updating that list. Also in Article 10, on page R11, this is section 15. This expands the in-service training and crisis intervention in mental illness crises, conflict management and mediation, and recognizing and valuing community diversity and cultural differences to also include training in identifying and reporting crimes of bias. Moving to Article 14 now, this is the Article 14 side-by-side on page R21, sections 19 and 20. Deal with the crime of assaults motivated by bias. Section 19 addresses the gross misdemeanor offense, and Section 20 addresses the increased penalty for certain felony offenses. They make similar changes that specify that the crime may have been caused in whole or in part because of the victim's actual or perceived status. They specifically include the victim's gender, sexual orientation, and gender identity in the categories of bias, and also expand bias crimes to include crimes against people that are committed against people because of their actual or perceived association with another person. Also in Article 14, sections 27 and 28, pages R27 and R28. These are sections 31 and 32 of the House language. These make similar changes in the felony and gross misdemeanor crimes of second-degree criminal damage to make those consistent with the changes that I described in the assault provisions. Finally, in this section for Article 14, Section 35 of the bill, which is on page R30, this is an amendment to the felony crime of harassment. Again, this makes changes that are identical and consistent with the changes I've described for assault and for damage to property. Madam Chair, that gets us through the first 8 provisions. I'd ask that you recognize Ms. Mullen to take over the last 4.
All right, Mary Mullen, also from House Research, please go ahead and walk us through the remaining provisions.
Thank you, Chair and members. Mary Mullen from the House Research Department. I'm going to be starting with item number 9. All of the provisions I'm going to be talking about are in the document labeled Article 6, Human Rights. This bill is House File 863, and it includes sections 1, 3, 10 to 14, and 16 to 19 of this side-by-side. Starts on R1 and goes throughout. Section 1 relates to certificates of compliance, and it adds a new section to the Minnesota Government Data Practices Act, which creates a cross-reference in statute related to access for data practices. So it doesn't change the law in this section, it just creates a new cross-reference. Section 3 adds protected class of familial status to the public policy statement in the Minnesota Human Rights Act. It's already included in the Minnesota Human Rights Act, just not in the initial policy statement for that chapter of law. Section 10 clarifies that a person can file a charge with the Department of Human Rights about discrimination online using an online system. Section 11 allows a person to bring a discrimination claim to request reconsideration on a determination that no discrimination was found 30 days after the determination is issued. Currently, that's a 10-day notice provision, and it also allows the respondent 30 days to request reconsideration as well. Section 12 clarifies that a person can file a charge with the Department of Human Rights about discrimination online. Section 13 allows a notice of a case filing to be provided electronically to the Department of Human Rights. Section 14 updates requirements and applications for certificates of compliance for public contracts, and it clarifies the application to the Met Council and updates language related to the application of affirmative action plans, and it removes some obsolete technical language. Section 16 makes conforming changes related to the other provisions of the bill. Section 17 provides data related to certificates of compliance submitted by businesses is classified as private data on individuals or non-public data when it doesn't relate to department employees. The bill provides that the commissioner's decision on issuing, revoking, suspending, or penalizing a certificate holder is public data, and that application forms for certificates are public data. This section also authorizes a commissioner to share private or non-public data with other government entities for compliance purposes. Section 19 makes those same changes to equal pay certificates. And that is all of House File 863. The next item on the list is item number 10. And this is a couple of provisions that come from House File 835. In the side-by-side Article 6, it's sections 7, 8, and 9, which you can find on R6, R7, and R8. The section 7 prohibits discrimination in housing, including home purchases and residential rentals against an individual who's receiving public assistance. Section 8 prohibits discrimination in housing by a real estate broker, salesperson, or agent against an individual who's receiving public assistance. And Section 9 provides a definition for the term public assistance program for the Minnesota Human Rights Act, Chapter 363A. The next item is item number 11, again from Article 6. This starts on R5. It's Section 6 of this side-by-side. The House language is from House File 403. And this was a bill that prevents employers, including labor unions and employment agencies, from requesting a job applicant's pay history. The provision doesn't prevent a job applicant from volunteering their past pay history if the employer does not prompt them or require them to provide it. The use of the job applicant or prospective employee's pay history to determine their pay or benefits creates a rebuttable presumption that an employer has committed an unfair discrimination in violation of the Minnesota Human Rights Act. This provision does not prevent an employer from providing a job applicant with wage and benefit information for a position or discussing the pay expectations with a client, with an applicant. And the final item on this list is item number 12. Still, again, we're in Article 6 of the side-by-side. This is House File 441, and there is corresponding Senate language with this piece. Sections 16 is on R13 and section 20, which you can find on R15. Section 16 allows the Commissioner of Human Rights to impose a fine for violations and allows the Commissioner to suspend or revoke a certificate of compliance when the fines are not paid or if the certificate holder has not complied with the statute. And Section 20 allows the Commissioner to issue fines for lack of compliance or suspend or revoke an equal pay certificate until all the fines have been paid for violations in relation to these two certificates that the Minnesota Department of Human Rights issues. And that is the end of the list.
All right, thank you, Ms. Mullen and Mr. Johnson. Similar to what we did in the first half of today's meeting, we're going to move to testimony, and then we will have time for questions. First on the list, speaking to the post-conviction relief language, I have Taomei Zhang. If you could introduce yourself for the record and then go ahead with your testimony, please.
Good afternoon. Chair and committee members. My name is Taomei Zhang, and I'm the Director of Intergovernmental Relations for the City of St. Paul in Mayor Melvin Carter's office. Today I have with me two additional individuals, Damu Vang as well as Linus Chan, to provide technical expertise on the bill. So I'll start by laying the context for the bill. So I am, not only do I work for Mayor Carter in the City of St. Paul, but I'm also part of the Coalition for Post-Conviction Relief, or the Expanding Access to Justice Coalition, which is made up of 30 nonprofits, government entities, labor, and other individuals who support post-conviction relief. So first I want to thank Chair Mariani, Chair Limmer, and Chair Becker-Finn for the opportunity to testify today. The coalition is super grateful for our chief bill authors, Representative Gowdy Herr and Senator Abler. We're also really grateful for the leadership and support of Representative Kelly Mueller, Senator Latz, Senator Fong Herr. They've been working with us for the past 3 years. In addition, one of our biggest champions was the former Senator Jerry Ralph. We're grateful for him, and we'll miss him greatly. And lastly, we wanted to thank Senator Limmer for your team who met with us a few weeks ago to explain this bill and share more personal stories with your team. So thank you very much for your time and attention. And then lastly, a huge thank you to Chair Mariani and his team for helping us since 2019 on this bill. So those are all my thank yous. Now onto the bill itself. Since 2019, the Post-Conviction Relief Coalition has been working hard to expand access to justice for immigrant refugee residents in Minnesota who have old criminal convictions. This bill creates a pathway to review old convictions that triggered immigration consequences and have led to residents in Minnesota receiving removal orders and even being deported. The majority of the residents in Minnesota who are impacted by these immigration consequences for state criminal convictions were told at the time of their plea agreement that they would never be deported back to their home countries. Many of these individuals are from countries of Laos, Vietnam, Cambodia, Somalia. They fled war-torn countries and came here mainly as refugees. And so in 2016, the administration had a targeted effort to detain and remove individuals from these countries who had old removal orders. And so that's the impetus for this bill. We're asking that the committee consider taking action on this bill quickly. Many believe that with the new administration that people are no longer being detained and deported, but that's not true. We've heard from immigration advocates that just a couple of months ago, a plane load of Vietnamese Americans were deported back to Vietnam and continue to be deported. And so it's urgent that this bill is passed and that individuals can remain with their families and families can stay intact. Today, you'll hear from Damu Vang, who is an impacted family member, and he can share his story about how his family is struggling to keep their family together. And then afterwards, if there's questions, we can direct the questions to Professor Linus Chan. So Damu.
Damu, please introduce yourself and then go ahead with your testimony.
Hey, hello everyone. I'm Damu Vang. As I say, good morning. I'm here to express my support for the inclusion of Post-Conviction Relief Bill, House File 833, and Senate File 1514 into the final Public Safety Omnibus Bill. So I'm 19 years old. I live in St. Paul, Minnesota. I'm the oldest of 4 children, and I'm also an Impact Committee member as well. So to tell you about me, I'm at a phase where I'm supposed to focus on higher education and where I would like to proceed with for the rest of my life. But that's when about 1 year ago, I overheard my parents speaking about deportation, and I actually learned my dad has a removal order to Laos, which I thought I misunderstood the conversation at first. So I went to my parents to clarify exactly what I heard, and to my surprise, everything they spoke about was all true. I'm still in shock today, and I cannot even imagine one without my dad not being at home. He has always given me these little lectures about making good choices, learning from his mistakes, and how important it is for me to succeed. I thought it was those usual parent lectures that they always give at first, but with everything that's happening, I'm starting to realize the true meaning behind it all. My father made a mistake in 1996 when he was 18 years of age, a year younger than I'm currently today, and he has never gotten into any trouble ever since. He came to the US in 1978 with his family, including my grandfather, who was a young Hmong soldier who fought in a secret war led by General Vang Pao, on which he fought on behalf of the Americans. Minnesota has been my father's home for nearly 40 years now. He and my mother have been together for 26 years, and he has raised me, my 3 sisters, and he even takes care of my grandparents. That's when, a couple months ago, my mother suffered from a stroke, and we have been struggling as she slowly recovers. It's devastating to think that things could get any worse with the thought of deportation that's always lingering over our heads. Because my dad, he is the foundation of our family. He is what holds us together, and without him, I do know that we may have a chance to fall apart. I would just like to say, please support post-conviction relief, and please consider giving people like my father another chance. Thank you for giving me such a great opportunity to speak, and most of all, thank you for allowing me to express and listening to me share my story. Thank you.
Thank you very much for your testimony. Really appreciate it. And if you could stick around, I'm sure members will have questions at the end, but we're going to move on to make sure we can fit everybody in today. Next on the list, we have Jessica Chase. If you could introduce yourself for the record and go ahead with your testimony regarding reducing or waiving traffic and criminal surcharges.
Yes, Chair Mariani and members of the conference committee. My name is Jessica Chase, and I am a member of the Legislative Affairs Committee of the Second Chance Coalition. I am someone that has been positively impacted by the ability of a judge to waive or to use the discretion when imposing potential fines and fees and the ability to waive those fees. Judges aren't currently required to consider a person's financial circumstances when they impose fines and fees, and it made a huge difference for me. The Fines and Fees Reform Bill would require a judge to consider the ability to pay before they impose those fines and fees, and I'd like to share my experience to show how important that is. In 2016, I pled guilty to a felony offense, and it was the suggestion of a probation officer to impose a $3,000 to $6,000 fine for my offense, along with probation. The thought of being guilty of a felony, unemployed, and facing huge monetary repercussions was extremely heavy. My attorney had the foresight to petition to the judge that as a newly unemployed person due to my conviction, I had no way to pay that large amount of money while trying to get back on my feet and assimilate to my new normal. My judge heard my fears, understood my uncertainties, and ultimately decided to waive all monetary penalties. Her decision gave me one less doubt about how I was going to pay for my bills. Because of her grace, I was able to take into account, or because of her grace and the ability and her ability to take into account my ability to pay for my fees and court mandated fines, I was able to go home knowing that I still had the ability to pay for my mortgage, my car payment, my student loans, my monthly bills, and to put food on my table. I was able to rest assured that my money was earmarked to pay for basic necessities, along with the trickle-down obligations of my conviction that included paying to be on probation, paying the transfer fee for my probation to be moved to another county because my offense was not in my county of residence, court-mandated treatment and therapy and medication, and the small yet significant cost of driving downtown and paying for parking. That can be a lot. I ask you all today to pass this bill that has been presented before you to make sure that all judges consider a person's financial circumstance when they sentence someone for breaking the law, and all of the expenses like probation fees and the cost of court-ordered treatment that a person has to pay to comply with their probation. While the guilt I have for violating the law still continues to live with me, the mercy I was shown by my judge has never been forgotten, and I humbly ask that others receive that same mercy across the board. I know not all judges take into account the ability for an offender to pay the fines and fees levied against them, and I would like to see that changed. The possibility for a judge to waive those fees is essentially helping someone like me, guilty of a crime, get back on their feet, not have to worry about how they're going to pay for their basic necessities, and ultimately end the cycle of reoffending. The waiver of my fees has been one of the best parts of my unfortunate encounter with the criminal justice system. I became unemployed due to my conviction, so the waiver of my fines and fees saved me financially. So now that I've been able to live a law-abiding life free from worry about how to move forward and with the ability to stay in compliance of all of my conditions. I would like others to feel that hope, and I feel that passing the fines and fees reform bill would be able to do that. Thank you for your time today.
Thank you for your testimony. Next, we have Susie Green. If you could unmute yourself and introduce yourself for the record, and then go ahead with your testimony.
Hi, good afternoon, everybody. My name is Susie Green. I am a Bridge Program Supervisor in Community Action Duluth. And I would first like to thank Representative Frazier and Senator Latt, for authoring the fines and fees reform bill. It's a pleasure, as I said, to speak with you all. I've been at Community Action since 2016, working with individuals and families to remove their transportation barriers. Transportation is a barrier for participants in my program, specifically of lower income, making it difficult for them to access resources and different opportunities that we have here in Duluth, and for them to thrive financially and socially. The way that the transportation program works is we offer various programs to help meet the needs that people are having to get their transportation barriers removed. A common barrier that I see is the inability to pay fines and fees due to past traffic citations. My participants simply cannot afford to pay the fines and fees they're given. And when I first meet with them, we work together to come up with individualized plans and ways that we can provide ongoing support and advocacy for them to overcome the barrier. I began doing this work in 2016 because of my personal situation where I racked up over the years almost $3,000 in fines and continued to go to court and was given the surcharge and different tickets. And I was a single mom and still had to continue to drive. I had 3 kids. I was young. One of them I was a teen mom with. And so I still kept reoccurring getting these tickets and these fines and didn't have a way to pay them. And so now I'm a woman in Duluth driving illegally. And so I worked through time to get my driver's license, and I learned the process, and I had some sacrifices and priorities I had to do. Once I did receive my license and was able to address my transportation, it was pivotal and it was an extremely important piece of me becoming successful and gaining independence. And so breaking the generational cycles that were in my family and also becoming engaged in my community. This fine and fee reform bill asks judges to consider waiving surcharge and base the fees for participants on their financial situation or status when appearing in front of them. What we don't want to do is criminalize folks for being poor. And as a transportation advocate and coach, I've known the importance of policy work. I've been doing this for a couple of years through the state and the city of Duluth. And we want to change the narrative ultimately and make transportation equitable for all. And so I ask of you to consider currently with this bill to make it to where judges have anonymity and consider people's financial situation when they appear in front of them. And access to transportation is the crucial link to people's success, self-determination, and the ability to participate in their community. I thank you.
Thank you for your testimony. Next, we'll have a couple testifiers on the civil asset forfeiture reform. We have Jason Flores. Mr. Flores, I know you've done this before, so I will remind you that we're a little bit behind schedule. So we're going to try to keep our testimony focused, and I have confidence that you're able to do that. So Mr. Flores, please introduce yourself and go ahead with your testimony.
Absolutely. Good afternoon, Madam Chair, members of the committee. My name is Jason Flores. I'm the State Director for Americans for Prosperity here in Minnesota. On behalf of all of our activists across the state, I want to say thank you for your attention to these important reform proposals to the state's asset forfeiture laws. And I also want to urge you to take action this session to protect the constitutional rights of Minnesotans. Americans for Prosperity in Minnesota has worked for years to make reforms to asset forfeiture laws, both here in Minnesota and across the nation. And as a participant in the interim stakeholder negotiations that led to this reform language, we strongly support it. You'll note a letter from that coalition in your packets today. This legislation is a strong step forward that will protect Minnesotans' property and due process rights and help keep the vast majority of claimants from being forced into an onerous and convoluted civil system in the first place. Right now, we rank poorly compared to the rest of the country in terms of our civil asset forfeiture policies, meaning that property owners here lack protections that residents of other states take for granted. Under our current system, property is allowed to be seized and title transferred if suspected of being connected to criminal activity or that represents the profits of wrongdoing. And all of that can occur without ever convicting an individual or even charging the property owner with a crime. Cars, cash, and other property are all forfeited under our current civil asset forfeiture laws. Now, right now, the property owner enters criminal court in some cases if they're actually charged, but the seized property itself enters civil court. In those proceedings, the burden falls on claimants to demonstrate their own innocence with a separate lawsuit against their own property. We got to file that within 60 days after seizure in order to even have a chance at getting it back. Needless to say, this process is time-consuming, expensive, and is generally unused. Because so many of these forfeitures are small dollar amounts, these massive procedural barriers put in place by the state quickly make the choice to pursue litigation more expensive than the value of any seized property. Many claimants, even those who are likely to prevail or who will never be charged with a crime, make the economic choice to simply walk away. And in fact, that's over 95% of the cases in Minnesota where property owners simply walk away and title is transferred administratively with no hearing whatsoever. Overreaching government bureaucracy and complicated legal process combine to literally take people's property, sometimes even of completely innocent owners. This bill helps change that, protecting property rights for many of these small dollar claimants and keeping most of them from ever having to enter that convoluted civil system in the first place, while preserving the ability for law enforcement to use seizure in cases where it is still warranted. There's bipartisan recognition across the House and the Senate, not only of the challenges of the current system, but also in favor of pragmatic reforms like this one. And unlike on so many issues, agreement here has already been reached among stakeholders between activists concerned with civil liberties and constitutional rights and with law enforcement and public safety advocates. Because of that, we strongly encourage you to continue to move these important reforms forward yet this session. Thank you so much for the time today, Madam Chair.
Thank you, Mr. Flores. Next on the list, I have Dan Kohler. If you could introduce yourself and go ahead with your testimony.
Thank you very much, Madam Chair. Members of the committee, my name is Dan Kohler. Today I'm testifying as a member of the Board of Directors for the Minnesota Association of Criminal Defense Attorneys, one of the stakeholders behind this bill. I cut 3/4 of what I was going to say in the interests of speeding this along. I think most of the members here have heard me testify before, but this is a strong bill. MACDL strongly supports it. It does satisfy all of the legitimate concerns of law enforcement and our state prosecutors, while still affording the protections that are necessary, particularly for innocent owners. It's got that elegant simplicity to it that we look for in legislation. I've gotten versions of the current bill found unconstitutional at the Supreme Court. I've got other challenges pending in the district courts right now. All of those are moot under this language. I like how future-proof it is. In some, this is actually going to hurt the pocketbooks of MACDL's members as attorneys. Under this language, I'm not going to be turning away innocent owners saying, you know what, the property seized isn't even as expensive as my attorney's fees are, because we've got those thresholds in place. A lot of property where people would come to me and say, hey, I can't drive to my outpatient treatment program because the state has our family vehicle, isn't going to come into play because that's not going to be seized. Those protections are long overdue, and I hope the committee respects and understands the fact that not only is this the type of thing that's long overdue, but we've got that bipartisan support for it right now. This, in my opinion, and in the opinion of MACDL, this is a no-brainer, and it should go through. Thank you.
Thank you very much for your testimony. If you could stick around in case there are questions at the end, that may be helpful. Next on the list, testifying to crimes motivated by bias, I have Zainab Abdi. If you could introduce yourself and then please go ahead.
Thank you very much. Good morning, everyone, and salam. My name is Zainab Abdi, and I'm a civic engagement coordinator with the Reviving Islamic Sisterhood for Environment, also known as RISE. Thank you, Madam Chair, members of the committee. I'm here to support the hate crime bill. I identify as a Black, Middle Eastern, West Asian immigrant Muslim woman. With the intersectionality of my diverse identity come fear of being attacked and assaulted due to hate crimes based on what I look like and what I wear. For decades, the Muslim community in Minnesota has experienced Islamophobia, but since 2016, hate crimes against Muslims have been on the rise. White supremacist rhetoric has led to lost lives, broken communities, and sacred spaces like our mosque being bombed and attacked. Muslim women are frequently targeted in Islamophobia hate crimes, especially Muslim women who wear the hijab like me. Reported data show that nearly 70% of crimes against Muslim women, and often gendered Islamophobia goes underreported. Those who survived these assaults has led to support from the state when they deserve the minimum compensations for their loss of work, loss of loved ones, and the trauma that they have been experienced. 3 weeks ago, the United States Senate overwhelmingly passed the Jabra Hair No Hate Act, while our national politics are deeply divided. Nearly every senator voted in support of this bill to address the troubling rise of hate crime across the United States. We cannot address a problem without knowing the true scale of the problem. That is why we are calling on Minnesota elected officials to follow the lead of the U.S. Senate and pass a comprehensive hate crime reform. This system of law enforcement only reporting created inaccurate data that does little to keep communities safe. Many victims are afraid to file police reports, like myself being Black and Muslim, and I'm afraid of going forward and doing that. Even when we do, many departments do not accurately label those incidents as hate incidents. In part of because of the peace officer standards and training board, hate crime training materials have not been updated since 1990. This had led to hundreds of hate incidents going uncounted. The U.S. Department of Justice estimated have put the number as high as 2 of every 3 hate crimes are not recorded in official statistics. We must allow for non-law enforcement entitled like community organization and Minnesota Department of Human Rights to file hate crimes report. These institutions are trusted by their communities and they can create safe, cultural relevant channels for victims to share their stories. With only few more days left in the state legislation sessions, state officials must prioritize making these reforms so that we can stem the rising tide for hate. Many U.S. senators across the political understanding that all of us want to feel safe in our community, and that legislation need to make this happen. No matter if they were Republican or Democrats, they voted to take action in combating hate. Now Minnesota law enforcement and lawmaker must follow this. It's time for our legislators to listen to voices of marginalized community, take actions, and pass this bill. Our safety should not depend on our faith, the color of our skin, or any other identities. We call on lawmakers to stop hate in Minnesota by passing this community-led piece of legislation. Thank you very much.
Thank you very much for your testimony this afternoon. Next on the list, I have Professor Jill Hasday speaking to Preventing Pay Discrimination Act. Dr. Hasday, please introduce yourself and go ahead with your testimony.
Chair Mariani, Chair Limmer, and members of the Public Safety and Judiciary Conference Committee. Thank you for inviting me. My name is Jill Hasday. I'm a distinguished McKnight University professor and the Centennial Professor of Law at the University of Minnesota Law School. I teach sex discrimination law and constitutional law, among other subjects. In my time today, I would like to make one simple but fundamental point. Asking job applicants about their pay history perpetuates pay discrimination. I'll start with some historical background before describing the current state of the law and the need for legislative action. Before 1963, it was perfectly legal to pay women less for doing the same job. This type of discrimination was pervasive and out in the open. For example, help wanted ads would list one salary for men and a lower salary for women doing the same work. Many hoped that the Federal Equal Pay Act of 1963 would end pay discrimination between men and women. But 58 years after the law's enactment, an enormous wage differential persists. The median earnings for women working full-time and year-round in 2019 were just 82% of the median earnings for male full-time year-round workers, with Black women earning just 63% of white men's earnings and Hispanic women earning just 55%. The latest studies estimate that America's wage gap will not close for white women until 2055, for Black women until 2133, and for Hispanic women until 2220. One important reason for this persistent wage gap is that employers frequently ask job applicants about their pay history before determining what salary to offer. This widespread practice means that workers often cannot escape pay discrimination by getting a new job. If a woman's first boss pays her less than men earn for the same work, the consequences can reverberate for a lifetime. Discrimination early in a career can lock someone into a permanent cycle of unequal pay. Unfortunately, federal law does not prohibit employers from asking about pay history. Instead, federal law accepts, even facilitates the practice. Employers sued under the Federal Equal Pay Act for paying women less will commonly defend their unequal pay practices by contending that they set salaries by relying on each job applicant's pay history. The United States Court of Appeals for the Eighth Circuit, which covers Minnesota, has accepted this argument, holding that it does not violate the Federal Equal Pay Act for an employer to pay women less if the employer determined pay scales by relying on pay history. I'll repeat this because it's important. Federal law does not stop employers from paying women less than men doing the exact same job, so long as the employer can point to the woman's pay history as the reason for her lower salary. The ability to rely on pay history provides employers with a ready-made excuse for underpaying women, but efforts to amend federal law to prohibit employers from asking about pay history have so far been unsuccessful. A growing number of states and localities have responded to this problem by enacting their own laws that ban employers from asking job applicants about pay history. These laws are aimed at ending the cycle of pay discrimination so that everyone can receive equal pay for equal work. The laws benefit women and anyone else with a history of being underpaid. To date, approximately 18 states and 17 localities have prohibited employers from asking job applicants about their pay history. A 2020 study by researchers at Boston University School of Law found that the enactment of state pay history bans led more employers to list their salaries in their online help wanted ads and increased pay for job changers by an average of 5%, with the pay of female job changers increasing by an average of 8%, and the pay of African-American job changers increasing by an average of 13%. In other words, adopting pay history bans made workers as a whole better off and also reduced both gender and racial wage gaps. Minnesota should join this reform movement. Every Minnesotan deserves equal pay for equal work. I encourage the Public Safety and Judiciary Conference Committee to include this policy in their omnibus bill. Thanks for your time.
Thank you, Professor Hasday. Next, we have Linda Soderstrom testifying on the banning housing discrimination based on source of income. Ms. Soderstrom, if you could introduce yourself and then go ahead with your testimony.
Good afternoon, Chair Becker, Mariani, and Limmer. I am am Linda Soderstrom, and I live in Southeast Minnesota, and I am reliant upon a Section 8 housing choice voucher. This subsidizes my rent through HUD in DC, and I pay 1/3 of the fair market amount, and HUD pays the other 2/3 amount. My Social Security check is around $900. So if I paid full fair market of $750, I would be very hard pressed. And having this income-based subsidy allows me to be a contributing member of society, despite my fixed low income. In 2015, at a complex called Crossroads at Penn in Richfield, when a new owner acquired the 700 units, 96% of those folks lost their affordable housing when the new owner no longer accepted vouchers or subsidies of any kind. I moved, and in 24 months was bumped again by a similar investor with only 30 days to quit. When you are in search of Section 8 housing, you must have a landlord who accepts the voucher. If a landlord cannot be found in 60 days, the voucher goes away for good. People who have waited years on wait lists to receive their vouchers can lose them in those first 60 days if no owner is found who accepts this subsidy. This new tenant protection, where source of income is not a disqualifier, asks that you, as landlord, interview me as an applicant side by side with any other applicant on the merits and screen me as an individual side by side. When I looked for housing after the Crossroads situation, I contacted 20 complexes every day for 20 days. And I never heard a single yes to my question, do you accept the housing choice voucher? And in fact, the Section 8 housing choice voucher was only listed in their advertising when it said Section 8 need not apply. So sometimes voucher holders live in their apartment homes for long periods. We're good people. We let you know when repairs are needed or other attention. This stability saves owners from constant rotation of their units and allows our neighborhoods to be financially diverse, as well as cared for. Within the COVID crises, we learned that subsidized renters were better able than others to pay rent in full, on time, and stay put for their public health and safety. When I was displaced from Crossroads with 2,350 others, I spent the next days, as I told you, searching. And that search is very emotionally and physically draining. The feeling that you have during that time, your lived experiences, the minute that door comes, that letter comes under your kitchen door, is I have nowhere to go, nothing to go there with, and I don't know what's going to happen to me. So even after this kind of search and twice being displaced in this way, I would just like to say that I am a good citizen and close by saying my Section 8 voucher does not interfere with me, with me and my life as being a good neighbor. And I hope you would consider the non-discrimination due to my source of income as a reasonable expectation. And in fact, during COVID, we learned that universal vouchers based upon need would not constitute a mandate upon owners, but rather the acceptance of the Section 8 housing choice voucher could exist to assist all Minnesotans to be housed. And thank you so much for listening to my story.
Thank you, Ms. Soderstrom. In addition to being a good neighbor, you are a good testifier. So thank you very much for spending some time with us this afternoon. Our final testifier today is April Cedillo, testifying on the increase in interpreter pay. Please introduce yourself.
Hello, thank you, Chair Becker-Finn, Mariani, Limmer, and members of the committee. My name is April Cedillo, and I'm a state certified Spanish interpreter. I've been working in the court since about 2002, and I'm the owner of an interpreting agency named Link Interpret. We opened about 12 years ago. We provide interpreters to law firms for interpreting in private work such as depositions and arbitrations. So I can provide a unique perspective on working for the courts as an interpreter because for years, most of my work was in state courts. And as the years have gone by, I've transitioned to private work, and I have experience running an agency, which puts me in touch with hundreds of interpreters working for both the private sector and for district courts. And I'm here today to urge you to support the Court Interpreter Bill on behalf of independent contractor spoken language interpreters who work for the state. So who are the interpreters for making this ask? The Equal Employment Opportunity Commission, the EEOC, classifies interpreters as professionals, just like judges, doctors, and lawyers. We're mostly women, people of color, and we're small business owners who work for ourselves as independent contractors. So what do? We bridge the gap for limited English proficient Minnesotans. We work in different areas like state-funded domestic abuse service centers, state penitentiaries, state-funded government offices, and we do a lot of work in criminal and civil district courts in the state of Minnesota. Without us, judicial partners such as judges and attorneys, support staff, and limited English proficient Minnesotans wouldn't be able to communicate with each other. Our services are indispensable to ensure equal access to justice for people of color and the immigrant community. And not only that, but we ensure that the courts run smoothly and efficiently by erasing the language barrier. So what is the problem that this bill will remedy? Well, spoken language interpreter compensation has not grown in line with other similarly situated language professionals who work in court. And as an example of that, I'd like to compare spoken language interpreters with interpreters of American Sign Language, or ESL. So our payment policies were set by the state back in 1997. And 24 years have gone by since then. Now, in those 24 years, Google tells us that the value of $1 has gone up by 65%. ASL interpreter pay has increased by 54% during this time. But spoken language interpreter pay has increased only by 4% in those 24 years. Yes, I did say 4% in 24 years. Not only does this disparate treatment of spoken language interpreters reflect poorly on the Minnesota judicial branch and the district court's obligation to equal access to justice, but we're also losing qualified interpreters who can't afford to support themselves working for the courts. We knew that our colleagues were dropping out of court work as the years have gone by, so we started informally tracking just in 2019, even before the pandemic, and we've lost about 20% of our active interpreters on the state roster just in this short amount of time. Low pay is the top cited reason for qualified interpreters looking for other work, and I can give a personal perspective on this. As the years have gone by, I have chosen to do private work instead of court work simply because it pays more. Although I've been working in courts for years, judges greet me by name when I step into the courtrooms. It's just not in my best interest to continue to do court work. And you can multiply this story many, many times over for other interpreters. And it is starting to become a problem. So what are we asking for in this bill? To raise spoken language interpreter pay, as ASL pay has been raised, to a point where we're not losing more interpreters, and to keep district courts working with certified and qualified interpreters. If we can do this, we're ensuring the efficiency and the legitimacy of the criminal justice system. We are helping prevent lawsuits concerning equal access. We're ensuring that the citizens of Minnesota can count on just prosecutions and upholding our state laws. But by not taking action, court processes can be called into question, and efficiency and upholding state laws can be jeopardized. So I'm asking you to please support spoken language interpreters so that we may continue supporting the state courts, our judges, district attorneys, public defenders, Minnesota citizens, and equal access to justice. Supporting the court interpreting bill is simply the right thing to do. Thank you, Madam Chair and members of the committee.
Thank you, Ms. Cedillo. I know in my own experience working in Hennepin County District Court, we are often waiting around for the interpreters because we don't have enough of them and they're running from courtroom to courtroom. So very familiar with the impact on the efficiencies in our courts when we don't have enough qualified interpreters available. With that, members, that wraps up our public testimony today. We did get permission to go a couple minutes over since we started late, so we will move to member questions and discussion. So I will keep an eye out for any hands, and we are open to discuss any of these provisions further. Or maybe our testifiers were so good, everybody's on the same page that we should support these things. Chair Mariani.
Thank you, Chair Becker-Finn. I couldn't resist because of the last testifiers. I just want to accentuate something with Ms. Cedillo. First of all, bienvenido y gracias por su testimonio.
Gracias.
Siempre me da un orgullo de hablar español cuando puedo.
It always makes me proud to speak Spanish when I can, and that's your interpreter at work.
Let me ask, several years ago, many years ago, I was asked to come in and do some interpreting. And I promptly messed everything up. And what I learned, and this is way before I think we even had like a certified program. This is how old I am. And what I learned was that when it comes to court interpreting, just like medical interpreting, it's not just about speaking the language. There's a technical language and knowledge that needs to accompany this, and the stakes are quite high. We're talking about constitutional rights in our court system. So, can you just expound a little bit about that and how difficult that is? Because one would think, lots of Spanish speakers to choose from. Yes, but not a whole lot of interpreters that are certified to do that. And that's a pretty major investment of time and resources, I would imagine, for people.
Absolutely. It's a huge...
Ms. Cedillo. Ms. Cedillo. I know the interpreters are used to talking so quickly to keep things rolling, but go ahead, Ms. Cedillo.
Thanks so much. Yes, Chair Mariani, it is quite the investment of time and education for us to become proficient in legalese, as most people who go to observe court know that sometimes it sounds like attorneys are just speaking their own language, and being able to interpret correctly legal procedures and legal testimony is definitely a skill set in and of itself, something that we study for and something that interpreters are tested on when they become certified to be able to work in courts. And I just offer a very quick example, which actually is not even a legal example. But if you type paper jam into Google Translate, what Google Translate will tell you in Spanish is the equivalent in English to jelly made out of paper. So it is more than knowing the words. It is being able to put a concept from one language to the next. And that is extremely important work when life and liberty are at stake.
Thank you. Any follow-up, Chair Mariani?
No, gracias. Agradezco mucho.
Muchísimas gracias. Thanks so much.
Chair Limmer.
Thank you, Madam Chair. I had a question regarding your proposal number 3, post-conviction relief. And the question I had is if a person had a previous conviction, does this provision or the proposal, does it specify or divide the severity of conviction? Are we dealing with minor offenses or that would be prevented from being deported, or is it across the entire spectrum of criminal conviction?
Yeah, great question. This is why we had Professor Chan on hand. So Linus Chan, if you could introduce yourself and then go ahead and answer that question.
Sure. My name is Linus Chan. I teach at the University of Minnesota, representing people who are held in detention by ICE. I also have been working with the Post-Conviction Coalition for a number of years. Senator Limmer, that's a very good question. I will just point out that, first of all, the structure of the post-conviction bill at issue, which is the time limitation, that itself does not divide or provide any sort of different treatment based on the severity of the crime. All of the current exceptions to the time limitations simply treats them all in the same category, and that's what this bill does. Our bill does not do anything different with that time limitation exception. It does not distinguish between severity of crimes. I will, however, note that underlying all of these exceptions is the requirement that there had to have been a flaw in the underlying conviction itself. Nothing would be possible under a post-conviction bill unless they can identify a substantive flaw in the conviction itself. This bill would simply allow a person past the 2-year limitation to file for post-conviction relief. But to answer directly your question, Senator, it does not treat different convictions based on different severity any differently, in line with the other exceptions to the time limitation bar.
All right. Thank you.
And to clarify too, this allows them to file the petition. It doesn't automatically green light their petition. It just gives them the ability to file it. Follow up, Chair Limmer.
I don't know if I had a follow up or not. However, I was kind of waiting to see if the Biden administration was actually going to change the policy, at least through an executive order, in reaction to a new administration changing a view from the previous one. And I believe they could do that. And like you say, in the comments, it appears as though no one really knows what the Biden administration is going to do. Is that correct? Is there any hints about it?
Mr. Chan, go ahead.
Yeah, so there are movements and different priorities. However, there doesn't seem to be this particular issue, which while we believe the Biden administration does have significant discretion, there is an issue with certain crimes that there is no movement without congressional movement. So for instance, specifically the issue that this bill attempts to address are people with very old convictions, people with convictions in which during the time that they received them, either were never put in removal proceedings, or when they were put in removal proceedings, they were told and relied upon the idea that because of their country of origin, they would not be deported to those countries. And there is not, to my knowledge, any discussion in the Biden administration of any sort of executive authority addressing that particular issue.
All right.
We of course, as a state, have the ability to at least handle it here in Minnesota. Additional follow-up, Chair Limmer.
You keep pumping me for more questions, Madam Chair. But, when I'm not putting my hand up. But why don't I change the subject a little bit? The concept of civil asset forfeiture reform. We have in the Senate 2 bills that are circulating, one by Senator Johnson, which matches up closely with Senator Mahler's, and then we have Senator Newman's bill. Slightly different approach, use of funds, that type of thing. Is there a cost associated with the forfeiture reform that you are proposing?
I am going to give that one to, luckily we have the chief author, 2 chief authors right here in the room, right. Vice Chair Representative Moeller.
Thanks, Madam Chair, and thanks for that question, Senator Limmer. So yes, we do have a cost, and you'll see in the offer that's made the line items where that's reflected. I will let you know that it's not finalized by the LBO yet, but there was a request made of the other proposal that you heard in your informational hearing, and there actually is a cost associated with that too. But that specific note hasn't been finalized yet, and I don't know if you've seen it. And if you want any more questions about any of those, the details or the numbers, I believe fiscal staff is on and could probably answer those questions.
All right.
All right, I think Representative Mueller did a great job of answering that question, but obviously if we can get more information. I know I had just received an email from John Walls, our fiscal staff, in the last couple of days regarding the fact that the other version of the bill does have a cost as well. Chair Mariani.
Well, Madam Chair, only because we have a little bit of time, I thought I'd follow up again with Dr. Chan to Chairman Limmer's question. What I do recall, but correct me if I'm wrong, Professor. What I do recall is that this issue became. I should be careful how I say this. I first learned of this issue during the Obama administration. That there were apparently steps that were being taken during the Obama administration. And I think what it tells me is that the issue is not so much a partisan issue as much as it is a choice for the state to be able to assert for itself what its appropriate, I don't know what the word is, outcomes, consequences, expectations are of its citizens, of its residents, relative to of holding them accountable for whatever wrongs they have done. And it seems to me that with many of these cases, that the posture of the state of Minnesota wasn't, oh, we're gonna give you, put you on supervision or time serving jail, whatever, and we're gonna deport you. And one of the powerful things that I've heard repeatedly from the many families, and we heard it earlier, was how much these individuals have subsequently become an important part of community life in Minnesota. So I threw out several things there, but I just wanted to, as long as I have a little bit of time, I really don't see this, and I know Chairman Limmer wasn't trying to take it into a partisan spot at all, but I, in terms of speaking publicly, want folks to know that this really has to do, in large part, with the authority and the scope of state decision making, and not let that sort of get hijacked by the federal government. Even decades later, to pile on, whole new consequences after, these cases have been adjudicated, accountability has been held, and redemption is present. So just, Mr. Chen, correct me if I'm wrong about that, or assert that I'm right.
Yeah, no, I thank you, Chair Mariani, because I do think this is an important provision in the bill. And I think it's one of those denser issues that's a little bit, you can't figure out exactly what it does just by reading the title. And so I do appreciate the follow-up on this issue. And, for me, it's really about, these are folks who had bad legal advice given to them through no fault of their own. And now they're the ones and their families who are paying the consequences of that. Professor Chan, additional follow-up.
Thank you, Chair Mariani and Chair Becker-Finn. No corrections, Chair Mariani. I think you encapsulated. This really isn't and I haven't heard anyone sort of frame it that way, but it is not a political question. It really is a question, unfortunately, of allowing people's expectations of what their convictions can really mean at the time that they were convicted. So thank you for framing it that way, and I think that is a correct framing. So thank you.
All right, we will go to Senator Latz and then we'll wrap things up. Senator Latz.
Thank you, Madam Chair. I'd like to follow up on the forfeiture matter. This forfeiture reform issue has been around the legislature at least since Senator Meem-Wah was chair of the Senate Judiciary Committee, which goes back to the very beginning of my service in the state Senate. And I was elected in the 2006 election. So, you know, the innocent owner issue has been around, dealing with case law as to who can qualify even to seek relief as an innocent owner. Issues of ignition interlock to avoid forfeiture has been around, taking of cash, and all of those issues have been around for a long time. The bill that we have before us now in the form of the House version, which is the same as Assistant Majority Leader Senator Johnson's bill, is a product of many years, actually, of a large stakeholder working group that even went so far as to bring in an outside mediator from out of the state of Minnesota, is my understanding, worked extensively to find a consensus. And while, you know, I personally would lean more toward Senator Newman's bill because I think forfeiture itself is a flawed concept, except that which is, you know, directly involved in the, well, I'm not even going to go there. I just think that the concept of forfeiture is mistakenly thought of as a punishment, which of course is an unconstitutional grounds for forfeiture in the first place. But that said, I've read both bills quite carefully and thought about this a lot. And I really believe at this point that the best path forward is with the House version and Senator Johnson's version. It has broad stakeholder consensus. It's the proverbial peace in the valley, which was hard fought to get to. I think it makes substantial progress, and it reflects the concerns and the interests of all the various entities that would be affected by forfeiture. So I would encourage us to go ahead and enact that forfeiture provision into law. Thank you, Madam Chair.
Thank you, Senator Latz. And as I wrap up, I do think, you know, despite sort of some of the outside narratives, I think, you know, in our discussion and the testimony today, I think there really are a lot of provisions here where we can come together that are not hyper partisan on either end of the spectrum. And I am very hopeful that we can work on those things, even if there are some other things that are a little bit more difficult to deal with. With that, we will start to wrap things up here. Chair Limmer, any comments about the plan for tomorrow? Oh, Chair Limmer, you're muted.
I'm just one
almost
of those,
made it the whole day.
I'm a slow learner, Madam Chair.
So close.
I just want to remind our committee that we're now considering 54 House proposals that have been put before us, and they are beginning to, they're beginning to pile up, and we're going to need some time to mull all of these over, which we have been doing, by the way, as you've presented them. I noticed that the crime victim area just today totaled about $17 million by a rough estimate, and which kind of highlights the lack, again, of a renewed or a new budget target, which would help us, give us a little indication of what path to go down. But as we mull these over, we're going to continue on our side having discussion and doing a finer focus on the actual language that the House has. And that's kind of where we are, Madam Chair.
So to clarify, Chair Limmer, so are we meeting tomorrow, or will we be having those conversations elsewhere?
Well, we're going to, I don't have an exact agenda at this moment, so we will be letting you know later.
Okay. Thank you. And I will say we would greatly appreciate any size offer, counter offer that you're willing to make. I know you've expressed some consternation with the way we've put out these offers, but any kind of feedback, especially on the ones that are not finance related, I think would be greatly appreciated by all of us as we try to get done what we can, despite those at the top not giving us our targets yet. Chair Limmer.
Madam Chair, I can appreciate that. I keep asking for more of a global, one big presentation. As of the 54 proposals, is this the end of your House offering, or are there more to come?
I can tell you that this does not include every single thing that we hope will be on the table. For instance, we haven't really dug into, I know some of the provisions related to emergency services and fire services, and I think there's a couple others as well. So we will, conversations will continue, and I see Chair Mariani has his hand up, so he may have a additional answer for you. Chair Mariani.
Yeah, and Chair Limmer, there's nothing preventing the Senate from putting an offer on the table. Nothing. I hear the budget target issues. That's, quite frankly, that's not consistent with what your majority leader has told the public, where he's made it clear in his statements that, there are issues that we're going to go over, and they're not just budget issues. But let's put aside our leaders for a second. You and I are both chairs of this conference committee. We can structure this conversation any way we want to. We can take actions that we want to take. We obviously can't act on the budget things right now because we don't know, what those numbers are going to be. Although, quite frankly, we can't arrive even at right now tentative agreements around those. We know that public safety is a core function of government, of state government. There are certainly core appropriations that we can tentatively say that there's a lot of agreement between us, and we can begin to draft and pencil those out. All of that would be an incredible comfort to the public who's counting on you and on me to make sure that our public safety systems continue to operate. I have to say, I'm just perplexed by the non-steps that our colleagues are engaged in at this point. The whole point is to take steps. And so we're reaching around, putting forward ideas that are really good ideas that often are bipartisan ideas, that often are ideas that are being carried in your body by members of the majority with passion even. And so I have to say, a reasonable person looking at this situation has got to be scratching their head and asking, well, what's going on? Let's give them an answer, Chair Limmer. The simple thing to do at this point, the powerful thing to do, is to put Senate ideas on the table and offer those up. That has not happened in over a week. You can't get to a negotiation unless both sides are putting their thoughts, their offers on the table. We may not like your offers, but we'll respond. Or we may well like your offers, and we will respond positively. That's all we're asking for. I have to say, I'm not. I hope our tone remains upbeat and positive here. I don't want my House members to feel that they're being criticized for attempting to get to an agreement, for putting ideas on the table. I don't think anyone in the public would think that that's a bad idea. So you know, Senator Limmer, I certainly hope that you will, I don't want to personalize this, that the Senate comes forward with their proposals so that we can then get to the negotiating part of this whole conversation. I have to say, I'm really pleased with the level of engagement that we've had, the inquiries from senators and reps, the rapt attention. It's all been very good. But at the end, you know, we have to take steps to act. And that's all the House has been doing at this point. And I hope that the Senate can reciprocate and do it rather soon because the clock is certainly ticking.
I will. I often, as chair, will talk about how chairing a committee is similar to being a parent. This is another one of those scenarios. You know, I tell my kids, you know, we can only control the things that we can control. I can't control whether the governor and the speaker and the majority leader come to an agreement today on those budget targets. But I think there are things that we can control as leaders right here in this virtual room. And I do hope that we can continue to keep the tone upbeat and do take those steps. Representative Frazier.
Thank you, Madam Chair. I know we have a short time, so I'll try to be quick. Listening to Chair Mariani, he kind of covered the narrative that I wanted to go to. I think, you know, we have a moment to show our fellow Minnesotans that we can work together. We may be divided by political party affiliation, but, you know, everything that's been presented here with the testimony from the victims, with testimony from advocacy groups that are in close proximity to these issues that are kind of, you know, dividing our state and creating these disparities. There are things that we can agree on. I mean, in a couple of the offers that we have provided you, there are essentially things that both Republicans and Democrats agree on. And it's very disappointing, especially after considering that Senator Gazelka said that we were going to address these things in conference committee. Those were his words. Didn't have any hearings. We're going to address these and work them out in conference committee. And I got to tell you, at this point, we're not working these out. You've got one party working very hard to put offers on the table and to even meet you in common ground with things that you agree on. And we can't even move those forward. When we can't even get just some mutual agreement that, yeah, those are fine. Let's try to work on the things that we don't have mutual agreement on. And that's got to be very frustrating. It's frustrating for me. I'm scratching my head. And I know it's frustrating for everyone that's watching, from the constituents that are contacting me, from folks that are not my constituents, that are from places around the state that are contacting me, wondering what the hell is going on? Why can't we have any type of movement and do what's best for Minnesotans? So I just think, you know, not even for political purposes or to support the House side, but just as a Minnesotan, and speaking on behalf of other Minnesotans, we've got to come together and get this done. And I think we can do that. And we just need to do our jobs. I mean, that's basically what people want us to do. They want us to do our job. Thank you, Madam Chair.
Thank you, Representative Frazier. And I'm getting the sign from House Info that we've got to wrap up our Zoom. You know, I have heard, I mean, even on some of the provisions yesterday with law enforcement, what I heard was us starting to come together on some ideas, you know, maybe not the specifics, but I think there is more common ground than folks often assume about these issues. So thank you to our testifiers, especially for taking the time today. It was very great to hear from all of you. Thank you, members, for your questions. And with that, we are adjourned.